welcome you to Day 4, Session 1 of the 7th Annual Criminal Law Review Conference 2025. You'd agree with me that it's been an exciting event from Day 1, Day 2, Day 3. Today, we'll be discussing Nigerian criminal law and procedure evidence. We'll take an annual survey of appellate court decisions for the period under review. We would like to call on any conferee from the Kogi State Government House, the Glass House of the Government House of Kogi State, to please give us an opening prayer before we take national anthem.
Okay, thank you very much. Thank you. Let us pray. In Jesus' name. Father, we thank
Please
you
be right.
for another beautiful morning. We are grateful to you for the success of this seminar so far. We are grateful to you for how you have preserved and protected all of us in the name of Jesus. We are grateful to you that today is yet another day. As we continue, we ask and pray that your Spirit will lead and guide us through in the mighty name of Jesus. We're grateful to you that at the end of the day, the seminar today will be an eventful one in Jesus' name. We commit all our facilitators into your able hand. We ask and pray in the name of Jesus that you help them and lead them in the name of Jesus as they impart this knowledge into us in Jesus' name. We thank you, our Father, there is none like you, and then you will be exalted in Jesus' name.
Thank you very much. You didn't state your name, sir, for the rapporteurs to get it. Please send it to us in the report. Thank you very much.
My name is Emmanuel.
My name is Emmanuel Ebremi.
Thank you very much, sir. Thank you very much. Thank you very much. We'd like to acknowledge the presence of distinguished guests and personalities who have made our time to be here today, including the organizers. We want to welcome Mr. J.B. DAUDU, Senior Advocate of Nigeria, the Coordinator of the Global Development Foundation. Please let's give a round of applause. We'd like to acknowledge the presence of the Chairman, Honorable Justice Professor O.A. Aclrc, retired. He's the Chairman of today's session. We want to welcome the presence of the lead presenter one, Professor S.T. Horn, Senior Advocate of Nigeria. Distinguished UNC. Thank you very much for coming, sir. We want to welcome our second lead presenter, no other than Adedayo Adedeji, Senior Advocate of Nigeria. Welcome, sir. We also want to welcome some of our other discussants who are watching online. Some of them are here present. We want to welcome Habib Oredola, Senior Advocate of Nigeria. He's online watching us presently and will deliver his paper therefore. We want to welcome Chinelo Ofegbuna, who is also online. She'll present her paper from there. Please let's give her a round of applause so she can get steamed up. We want to welcome Chinelo Obozo Anarodo, Esquire, partner in the firm of J.B. DAUDU & Co. Please let's give her a round of applause. We want to also welcome Baratu Dangana, Esquire, a partner in the firm of J.B. DAUDU & Co. We welcome you very much. We also want to recognize other distinguished guests. We want to recognize the presence of Honorable Justice Jamilu Suleiman. Welcome, sir. Thank you very much. He's here Day 1, Day 2, Day 3, and he's here today again. We want to welcome and acknowledge the presence of Senior Magistrate Teresa Ntino Kweje Otu. Please let's go around for questions here from now to today. We want to acknowledge the presence of Mr. P.B. DAUDU, Senior Advocate of Nigeria, former branch chairman of the Nigerian Bar Station Kwari branch. We want to welcome all other judges, magistrates from the FCT, Kano, Kogi, and all distinguished conferees who have made our time to be here. We want to recognize the Kogi State Government, the Federal Capital Territory Administration, the Body of Benches, the High Court of the FCT, and the Kano State Judiciary. Thank all other conferees from various law firms. We want to also recognize one of the conferees who's been the most prompt since the event occurred. We want to recognize Umasabo, Prosper, Organic Payment. He's from North Catholics. He's always the first to get here. Thank you very much. We recognize you. Before I hand over the microphone to the chairman, I'll just take the profile of the distinguished panelists so that we can have an idea of their background and pay attention to what they have to say to us today. We would like to take Honorable Justice O.A. Aclrc, Honorable Justice Professor O.A. Aclrc. He's a retired justice. He had a distinguished career as a judge in Nigeria where he served with integrity and contributed significantly to the Nigerian judiciary. He presided over numerous cases in both civil and criminal law, handling significant cases that contributed to the development of Nigerian law, particularly in the area of evidence. His tenure as a judge was marked by his commitment to upholding the rule of law and justice. While in service to the judiciary of Kogi State, he was the judge designated to try corruption cases filed by the Economic and Financial Crimes Commission, EFCC, and the ICPC, Independent Corrupt Practices and Other Related Offences Commission in Kogi State from 2008 to 2023. He is someone who has given considerable attention to the study of the law of electronic evidence. He is unarguably the leading authority on the subject in Nigeria. Please, let's give him a round of applause. Professor S.T. Hon is a prominent and distinguished senior advocate of Nigeria, having demonstrated excellence in legal practice and advocacy over the years. His legal career spans various areas of law, including litigation, commercial law, corporate law, public law, constitutional law, and human rights, in advocating for the protection of citizens' rights and the rule of law. Professor S.T. Hon, Senior Advocate of Nigeria, has contributed immensely to the development of Benue State and Nigeria at large. He has influenced the employment and appointment of many Nigerians at local, state, and national levels. In recognition of his massive exploits as a lawyer, author, and his consistent contributions to the well-being of humanity, Boko Traditional Council in 2017 conferred him the honorific title of Afa Atindi Uboko. Please let's give a round of applause.
I apologize, I didn't say chief at the beginning, but that's the professor chief. It's honorific, I'm sorry, sir, honorific. Honorific. Thank you very much. Chief S.T. Hon has earned recognition not only in Nigeria, but also internationally for his legal expertise and contributions to the development of law and justice. We also want to see Mr. Adedayo Adeji, Senior Advocate of Nigeria. He began his legal practice at the firm of J.P. DAUDU & Co., where he advanced to the position of head of chambers in the firm's Abuja office. He is known for his expertise in various legal domains, including general litigation, appellate practice, constitutional and statutory interpretation, criminal law, pre- and post-election dispute resolution, where he has represented clients in high-stake cases across different jurisdictions. In recognition of his distinguished contributions to the legal profession, Mr. Adedeji was conferred with the prestigious title of Senior Advocate of Nigeria in 2023 by the Legal Practitioners Privileges Committee. His achievements and progression underscores his commitment to the advancement of justice and inspires the upcoming generation of Nigerian lawyers, laying a foundation for a career marked by exceptional client representation and legal proficiency. Next is my leader, Habib Oredola, Senior Advocate. Please let's give a round of applause. My leader, Mr. Habib Oredola, Senior Advocate of Nigeria. He's a seasoned litigator, having acquired sizable experience from the law office of Paul Usora & Co., Ajumogobia and KK, where he was very active in corporate, product liability, oil and gas, litigation, and the litigation unit of both firms. Mr. Habib, Senior Advocate of Nigeria, is a problem solver with versatility in developing enterprising legal solutions for companies and individuals. He specializes in commercial litigation and criminal litigation, and has litigated an extensive range of issues, including oil and gas, banking, commercial transactions, intellectual property, infringement and enforcement, contracts, law, admiralty, election matters, and employment matters. Please let's give him a round of applause. He joins us online. Chinelo Ofoebunam is a senior associate in the firm of Aclrc, a firm based in Abuja. She's a dedicated and ambitious legal practitioner, arbitrator, and the arbitral secretary of the law office of Aclrc. She's an executive of the Women and Girl Child Capabilities Enhancement and Empowerment Organization, a volunteer at Develop Center for Africa. She holds several degrees, LLB, and she's also an LLM student at the Northeast University School of Law in Boston, USA. She's a certified associate of Nigerian Institute of Chartered Arbitrators, an arbitrary Chartered Institute of Mediation and Conciliation, and a graduate member of Chartered Institute of Secretaries and Administration in Nigeria. Please let's give her a round of applause. She joins us online. We also have in our midst Chinelo Ogbozor-Anarodo. She's a partner in the law firm of DAUDU & Co. She's a seasoned legal practitioner with a robust background in litigation, soliciting, professional ethics, legal drafting, and more. She holds a Master's of Law in Criminal Justice and Criminal Law. Please let's give her a round of applause. Baratu Dangana Esquire is passionate about core legal practice as well as dispute resolution. Her desire for excellent legal practice led her to serve in the prestigious law firm of DAUDU & Co, where she was duly retained as counsel after National Youth Corps service. She was called to the bar in 2007 and is presently a partner at the firm of DAUDU & Co. She graduated from Usman Danfodio University, Sokoto, the Nigerian Law School, Lagos, and has an LLM from the University of Jos, Nigeria. She has written several publications and made several presentations, such as Youths and Crime in Nigeria, Perspectives on Domestic Violence in Nigeria. To mention a few, she's a certified mediator, an arbitrator, and a member of the Institute of Chartered Arbitrators, an institute that trains and certifies arbitrators and mediators in Nigeria. She's a member of many other professional bodies, to name a few. We welcome you and we thank you for coming. We can't wait to hear you. Thank you very much. Without further ado, I'll hand over the microphone to the chairman of the event to take us through. Thank you, sir.
Thank you very much, Mr. Oni Emmanuel, the moderator. I want to count it a mark of great privilege and honor to chair this important session of this program, which I recall the coordinator himself described as the flagship of this conference. Well, let me say, the moderator has extensively established the protocol. So there's no way I can do better. So I stand on the protocol established. So we have the rare privilege of having as speakers this morning very erudite scholars and giants in our legal community. First, we have Professor S.T. Horn, Senior Advocate of Nigeria, and Mr. Adedeji, Senior Advocate of Nigeria. You will agree with me that these are men whose intellects have illuminated the corridor of jurisprudence in Nigeria. And so we are in here for a very wonderful time. Professor Horn, Senior Advocate of Nigeria, we all know somebody who has been very rigorous in his intellectual contribution, that has shaped the thoughts of our jurisprudence in Nigeria, particularly in the law of evidence. His writings and books have enriched both the bar and the bench, and he has been a great torchbearer, in the advancement of the law procedure in this country. So we're going to gain from his intellectual capacity this morning, and he's going to guide us on what has happened to the law and procedure and evidence in Nigeria in the last 1 year. Similarly, we have Mr. Adedeji, Senator of Nigeria, who stands as a consummate advocate. Somebody I have interacted with. I've seen him as a young, vibrant man with very clear thoughts, and he can be very meticulous also in his reasoning, and also innovative in his arguments. So to have these two legal titans lead this cause today, I hope will be a great inspiration to us and a challenge too. We have an array of discussants who will make their contributions. Habib Oredola, Senior Advocate of Nigeria. I quickly found out that he is the son of our daddy here, distinguished Honorable Justice Oredola, JCA, retired. Congratulations, sir. We also have Chinelu Ofuebuman, Esquire, a discussant. We have Chinelo Obuzo Anarado, is here in the house with us. We have Baratu Dangana, Esquire. I'm sure he's online. Oh, I beg your pardon. Okay, so you are here. So the topic for this morning, this session, is Nigerian criminal law, procedure, and evidence, an annual survey of appellate court decisions, appellate court decisions. I remark here that the topic will give us updates on our criminal law in the last 1 year. And of course, that has been the task of the Rule of Law Development Foundation, to remind us how the law has been developing, or how decisions of courts have not been allowed the law to develop. Whichever way, we have always been deeply educated, by this session. Of course, basically with the law should really not be static. So what we are going to experience here is going to be development of the law, development of procedure, and development of evidence in the last 12 months. Law, of course, rapidly develops, and judicial pronouncements, particularly from the appellate courts, they give us insight into how we are making progress. So these great scholars who will discuss and who will share their opinions on the decisions of courts on law, procedure, and evidence in the last 1 year, I'm sure will give us some benefits. So my counsel here is that we should open our minds and listen to them, and we sharpen our minds too. Let's follow their discourse so that at the end of the day, we can make our contribution. I've had the privilege of reading the two papers to be presented by Professor S.T. Horn and Mr. Adedeji Adedayo, both senior advocates of Nigeria. Well, my comments are reserved until after newspapers and the discussants have expressed their views. So it's my great honor, therefore, at this stage, to invite Professor S.T. Horn, who is going to be the lead speaker this morning, to the podium. Shall we just give a round of applause as he takes his time?
Good morning, my Lord the Chairman of Session. Good morning, my boss. Our host is always hosting us and enabling us to exchange ideas. Good morning, my Lord, JC retired, leaders and advocates of Nigeria, my colleagues. Ladies and gentlemen, as a matter of fact, this paper in less than 6 hours, because yesterday, and I'm sure one of the lawyers who reminded me to be here, I totally forgot. But I was so lucky that the Lord herself led me to some very good authorities to discuss today. So, having observed this protocol, my introduction goes this way. The word annual survey were, and of course I wrote was wrongly, were taken into account in my preparation of this paper, which took place between yesterday and this morning due to a grueling schedule. This first influenced my decision to restrict my research to the 2024 and the 2024 judicial years. My focus, therefore, is just to pinpoint as many new developments in criminal procedure and law of evidence applicable to criminal trials as I can lay my hands on. As a practicing lawyer, I'm strongly persuaded that the few areas I have discussed here will be of assistance one way or the other to this august gathering. Main paper discussed. I have subdivided this paper, there's no comma there, so sorry, into segments, each touching on some of the matters and issues that emanate from or affect everyday criminal trial proceedings. I must confess that due to lack of time between the time of preparation and the time of presentation of this paper, the arrangement of the subtopics has not followed any particular order. Kindly understand with me. So the first subtopic is when the evidence of an IPO amounts to hearsay. The general rule, as we all know, is that the evidence of an IPO is not hearsay whether or not he participated in all aspects of the investigation. During the period under review, however, the Supreme Court improved on this general preposition, as can be seen in at least one decision here discussed. In the case of Okon versus the States, it's a 2025 decision, the Apex Court held that an IPO can only competently give evidence of what he personally discovered in the course of investigation. Consequently, that evidence by him of what an eyewitness told him is inadmissible hearsay if it is intended instead of is and putting was. An editorial editing, you worry me, forgive me, is intended to establish the truth. However, I did further research and I discovered that in a later decision by the same Supreme Court, in the case of Adamu against Federal Republic of Nigeria, the Supreme Court took another route, and I quoted a long winding dictum there. You can read it. I think the two positions are conflicting, with due respect. Another instance when the evidence, one, is missing, The evidence of an IPO which classified as hearsay was pronounced upon by the Apex Court during the period under review in the case of Mohammed against States, the Aclrc JSC lead judgment. Thus, however, this general rule applies only where the statement was rendered by the accused person in the English language or pidgin English and recorded as such. He relied on the previous decision of the Supreme Court, where the accused person renders a statement in any other language and it is interpreted and translated into English language. A policeman or interpreter who interpreted the statement into English language must be called to testify. And if the investigating team member who tendered the statement was not the one who interpreted the statement into English language, the statement will amount to documentary hearsay and it is inadmissible. So he concluded. Again, the Supreme Court unfortunately overruled itself or contradicted itself. In another decision, the above will however not be the legal position if the statement had been made in English and interpreted into the language understood by the accused person, in which case any other police officer can tender it. So it's not contradiction per se, but the first one says if it's made in that language and translated into English, then it must be tendered by the interpreter. This one is saying that if it is made in English and interpreted to the person who signed it in that language he understands, then it can't be documentary hearsay. There are two opposites, but not necessarily contradictory positions. So the reason of the Supreme Court is in that long-winding dictum. The second subtopic is whether the evidence of an exhibit keeper is hearsay. I brought this one out because it is novel. I don't think, even as an author of evidence, I've come across anything that has to do with evidence by an exhibit keeper being classified as hearsay. So when I stumbled on this 2025 decision of the Supreme Court, in the case of Issa against States, I felt I should also bring it to our knowledge or notice. Sanke JSC held as follows. The appellant argued vehemently, very so, that the testimony of PW6, the exhibit keeper, is hearsay. He argued that the exhibit keeper had no first-hand knowledge on the robbery and so was not in a proper position to explain the exhibits. I note that the testimony of the PW6 based on the exhibit he received and stored. Whatever explanation he gave before the trial court was not only in respect of the aspect of handling exhibits when they were handed over to him. The testimony or evidence of an exhibit keeper is generally confined to one of facts within his knowledge. It will therefore not amount to hearsay where he gives evidence as to the nature of exhibit he received, as in the instant case, which is very sound reasoning with due respect. The next subtopic is whether the police must investigate a crime before arraigning an accused person. We have been confronted with such issues before. Supreme Court had opportunity to pronounce on this in the 2025 decision. That is the case of OPDC Properties Limited versus the people of Lagos State, where at that JSC heard. There's no law in Nigeria today, not Nigeria, in Nigeria today, which makes police investigation of any person in condition precedence to lay a charge before the court against the person who is reasonably suspected of having committed an offense. It sounds odd that the appellant will contend that because he was not investigated by the police, he should not be charged before any court. Investigation of a crime is what generates evidence for effective prosecution of an offender. If there's no investigation, and by that there's no credible evidence to prove the crime beyond reasonable doubt, it is the prosecution that will suffer the loss to begin on the person charged, not charged. There's a missing T. I'm so sorry once again. This dictum has confused me to a very reasonable extent, because if the prosecution can't prove because they didn't investigate, why are they arraigning the person? So at the end of the day, the Supreme Court appears to have agreed with that, even though from the beginning they excoriated that submission. Now, the next subtopic, which is also a matter of practice to guide us, and which is also a recent development to the best of my knowledge, is whether proof of evidence is synonymous with extrajudicial statements. The Apex Court heard in the case of Okemini against COP 2024 that these two phrases mean the same thing. Consequently, that counsel is free to use them interchangeably, because that issue was raised on appeal, and the Supreme Court said no, it's just semantics. The next subtopic is the right of an accused person to be served with proof of evidence even when tried summarily. This issue has been confronting criminal litigation in courts of law in Nigeria. The fact that an accused person has elected to be tried summarily alone does not entitle him to be availed the proof of evidence, via the recent case of Kemini against COP. The Apex Court further held that a criminal procedure law stipulating summary trial should not be construed in such a way as to come into conflict with section 36(6)b of the Constitution, which has guaranteed to an accused person the right to be availed facilities for his defense. Ogunwumi JS, who delivered the lead judgment, however, provided the following exception to this rule on page 503. So the rule is that summary trial, they must provide you, even in summary trials. I know that we have had matters in the Federal High Court where the summary trial procedure is involved. So, and when I was a junior counsel in the magistrate's court, where no proofs of evidence are served. Now, the Supreme Court has overturned that now. At the request of an accused person, the prosecution is under obligation. You can cite this decision to secure that. But there is an exception provided by Honorable Justice Umiju, who delivered the lead judgment. My Lord said, my Lords, I do not disregard the fact that on some extraordinary occasions, the witness statements or the publication of the same may need to be withheld from publication, even to the defendant, either in the interest of the complainant or where national security is concerned. The interest of the complainant here is what I don't understand, because it wasn't explained, but maybe in the case of rape of a minor, maybe that protection could be afforded to the prosecutors. The next subtopic is needlessness of talk identification if the accused person was already identified by his voice and the locus criminis. Identification evidence is important, and one type or species of authentication evidence is not superior to the other. The Apex Court established this fact in the recent case of UTAKO-ABUJA against the state. It's a 2024 decision of the Supreme Court, where I heard that appellant, having been identified by his voice at the bank when he was attempting to withdraw the money, needed not be identified in the dock again for him to be fixed with criminal liability. So, dock identification is not important when another form of identification had taken place before. In this case, voice identification. Exception to the rule that the prosecution must prove voluntariness of the confession in a trial within trial. This is normally, if you read my book on the law of evidence and several other decisions of superior courts of law in Nigeria, of record in Nigeria, you discover that the prosecution has a duty throughout the trial, the main trial, and then again in the void die, or the trial within trial, to prove the elements of voluntariness in case of the void die. Now, I've said it is settled law that the prosecution is under duty to prove the voluntariness of the confessional statement in a trial within trial. However, if during the same void die, the accused person turns round to deny making the said confession, the judge will be at liberty to admit it in evidence, even if he had committed the error of placing the burden of proof on the accused person. The Apex Court arrived at this decision in the recent case of Halilu against Katsina State. It's a 2025 decision, where UWA JSC lead judgment held thus. In the instant case, the legal judge, though, adopted the wrong procedure of law by making the appellant prove the voluntariness of the confessional statement in the trial within trial, was right to have admitted the statement in evidence as soon as the appellant retracted the said statement. So once you raise objection in the main trial that your statement is voluntary, but you go during the trial within trial avoid that to claim that you didn't make it. They are two different things. Then, in some decisions which I didn't consider here, the Supreme Court said the trial within trial can terminate at that point, and the documents will be admitted. Also, when the accused totally denies under cross-examination during the void of making the confession, but the mini trial proceeds to conclusion and the trial judge admits it in evidence on the basis that it was retracted. That is not admitting it that it was made voluntarily, but now, during cross-examination, the accused in this case, which I will cite, admitted, just rather said that I didn't make it. He wasn't insisting on the involuntariness of the statement. So the Supreme Court said that if the judge now admits it, that look, retraction of a confession is not enough to deny it to be admitted. If the judge takes that decision, then the accused person's challenge before an appellate court should no more be that the confession was involuntary. I hope we are following. Your initial objection was that this confession was involuntary. Under cross-examination, you begin to tell, you admitted that no, it is voluntary, but I wasn't the person who made it. And the judge admits it on the score that, look, a retracted statement is admissible, whether you retract it or not. Then, if you are appealing, you can begin to raise grounds of appeal alleging that the statement was involuntary. The judge was wrong to have admitted it on the ground that it was voluntary. No, you must follow the decision that was delivered. Jare JSC, my lord, in Elias against State, citation provided, made this statement. He said, as stated earlier, the appellant's counsel objected to the tendering of exhibits 5A and B in evidence on the ground that the trial judge rightly paused the main trial and conducted a mini trial to determine whether or not the statement was voluntarily made. During the trial within trial, the appellant testified. While being cross-examined by the respondent's counsel during the mini trial, the appellant completely denied making the statement. In the ruling delivered upon the conclusion of the trial within trial, the learned trial judge came to the following conclusion. It was quoted in extenso. But I say ... Evidently, the trial court came to the decision that the actual complaint of the appellant was that he did not make the statement at all, not that he made it under duress. That being the decision of the court, the court of appeal, the appeal or complaint of the appellant should have been channeled towards challenging the decision. However, the appellant has chosen to persist in the argument that the statement was not voluntarily made by him to police officers. Wrong approach. As a matter of acceptable procedure, as the next statement, and in agreement with the above decision, once a voir dire has been conducted and the confessional statement admitted in evidence, it would be idle for the accused to leisurely argue on appeal along the lines of the said statement being involuntary. Rather, he should impugn the voir dire if he hopes to succeed on appeal. This was the decision of the apex court in the recent case of Igenti versus State. Citation supplied. Subtopic, the next one is when the confession of an accused person will not bind a co-accused. Generally, a confession made by an accused person in the presence of a co-accused binds a letter if he does not show any remonstration or disagreement therewith. However, the apex court provided the following exception to this rule in the period under discussion here, in the case of Aclrc versus State, 2024. I felt that this is important for us to know, to update our knowledge, exception to that rule. In the circumstances of this case, there's absolutely no indication from the record that the appellant hearing heard or was present when the co-defendant made his extrajudicial statement or to avail him the opportunity to report same orally or in writing. The argument of the respondent that the appellant tacitly adopted SB 11 because he confessed the same facts in his own statement. SB 12, however, has traction in this case. However, where the statements are radically different, the court cannot presume Section 2494 of the Evidence Act against the defendant. Now, let me pause here to explain something. Sometimes the act of cross-examination is very important in trials. The prosecution comes, tenders a confessional statement that implicates your client who is a co-accused person. There's no evidence left to show that that statement was made in his presence and that he also adopted or kept quiet. Then, counsel representing the innocent, quote unquote, co-defendant will now jump up and begin to cross-examine. What's my client there? Wrong cross-examination, just leave it. This authority will help you in your final written arguments. Now, the next subtopic is admissibility of facts not otherwise relevant. This topic has been discussed extensively when I'm reviewing my book. This is an authority I will include because some facts are remote, some are direct, some are not direct, some are relevant, some are not on themselves or by themselves relevant, but they are reckoned by the Evidence Act as being relevant. Now, if we read this dictum by Tsamani Jess, in the case of Asa against the state 2025, we will appreciate some of the circumstances so that both defense, prosecution and defense counsel and the magistracy or the bench will also appreciate the fact that when such issues come, that this type of authority will be a guiding light. This was what my Lord said. As rightly observed by the learned trial judge at page 126 of the record of appeal, exhibits B and C are very similar. In both statements, the appellant narrated how the deceased was arrested, how he escaped from custody, his rearrest and shooting in the leg. What I find to be material and relevant here is that the statements are not direct, positive and unequivocal admission by the appellant that he shot the deceased. The statements, however, established that the shooting of the deceased was done in the presence of the appellant, only that the appellant denied that he personally shot the deceased. Further, the facts are stated in this relevant to the facts in issue by virtue of sections 5 and 70 of the Evidence Act 2009, and in conjunction with other facts proved in the case, are capable of establishing the guilt of the appellant beyond reasonable doubt. So you can see that those facts were not directly indicting of him, but they were now brought in having regard to some collateral facts. Prosecution, defense, bench, it is good for us to know these things. In other words, exhibits B and C, though not confessional of the crime charged, are part of the prosecution's case, which the court was under a duty to rely on in the process of evaluating the evidence. Section 9B of the Evidence Act was cited is there for us. He concluded as follows: I am of the view that exhibits B and C are relevant evidence when evaluated together with other pieces of evidence at the trial, are relevant in the determination of who shot the deceased. So, on that score, that authority is a recent development. It has also assisted and it will assist us going forward in our practice. Now, subtopic, again, exception to the rule that objection to a charge sheet must be taken immediately after the charge is read to an accused person. This occurs every day in criminal trials. The general rule is that objection must be taken when the charge is read to the accused person before he takes his plea. There are so many decisions that are cited, one within the annual review. However, within this period of the review and in tune with settled case law, that an unsigned originating process makes it incompetent, which can be raised at any time, including on appeal. The Supreme Court has heard that objection to a charge, on the ground that it was not signed, can be taken at any time, including on appeal. I cited a 2025 decision of the Supreme Court. Now, the next subtopic is whether failure to take an locutus is fatal to the proceedings. Our respected jurists in here, and for practicing lawyers, we are always exploring for technicalities. This is also important because I don't think I have come across this in my practice. The question whether failure of a trial court to take an locutus is capable of nullifying the trial and conviction of an accused person featured prominently in the case of Lawan versus Federal Republic of Nigeria. Lawan was a member of the House of Reps, we all know the case. In dismissing arguments in that direction, the Apex Court held that an locutus is not a defense for the accused person. Neither is it necessary for a trial court to invoke. The last it is cancelled. Further, that an agricultus is not a right in law or a fundamental right under the Nigerian law of failure, but is only desirable in consideration of factors that may influence the mitigation of heavy punishment to a lighter one. Thus, the failure of the trial court in this case to avail the appellant that opportunity was not sufficient ground to overturn the trial court's decision. Conclusion. I have confessed above that the decision of the Supreme Court delivered between 2024 and 2025 were randomly selected since the organizers gave me a carte blanche. As stated above, however, I subjectively told myself that as a practicing lawyer, the decisions discussed will be of tremendous benefit to all of us gathered here, as some of the ratios and dicta are novel. Thanks for listening, and God bless us all.
Thank you very much, Professor On, for this erudite paper, giving us your thoughts on some of the items that we have discussed. Shall we give him another round of applause in recognition of his contribution? So I will quickly shift over to Mr. Adedeji, Senior Advocate of Nigeria, to take the floor.
The Chairman of Session, my noble Lord, the Honorable Justice Alaba Ajile retired, the coordinator of the Rule of Law Development Foundation, our leader, our father, our mentor, JB DAUDU SCM, Leonard Sioux present, my noble lords, your worships present, distinguished colleagues, both online and on-site, the fourth estate of the realm, ladies and gentlemen. I'll start on the premise of first expressing my deepest gratitude to the organizers for extending another opportunity to me to express my thoughts on this topical issue. And it is particularly profound to me that I have the privilege of sharing the podium with erudite scholars on this particular area of law as a person of Professor S.T. Horn and my own Professor Ajileo. Once again, I thank you very much for that opportunity. I have prepared a paper which I have shared with the organizers, and so therefore for the purpose of this discourse, I'm going to be speaking to the paper, highlighting those important areas that I think is relevant for the purpose of this discourse. So permit me, if you notice that I'm jumping some areas, what I've simply just done on the circumstance is just to speak to the paper by highlighting those very important areas that I think will bring about further discussion here this morning. And I start by saying that this paper undertakes an annual survey. That's the top paragraph in the introduction. I'm going to skip the first two paragraphs. This paper undertakes an annual survey of some of these appellate decisions, drawing attention to the principles they establish, the safeguards they enforce, and the challenges they expose. It also interrogates areas where legislative drafting, judicial interpretation, or institutional practice has created gaps that undermine the effective protection of the accused, as well as smart prosecution by prosecutors. In so doing, it argues that the primary aim of the criminal process should be to achieve justice that is not only delivered, but also perceived as being delivered, justice that safeguards society while respecting individuals. And I start with the foundation, which is charges. Having set the stage demonstrating that the charge that is effective not only organizes the failures of trial, but also wastes scarce judicial time and resources. In the case of Gideon versus the state, this is what my Lord the Supreme Court had to say. My Lord AClrc, which is a 2025 decision, underscoring the importance and the effect of failure to sign the charge by the prosecutor. It cannot be gainsaid that the charge information and regulating process like the read of summons and regulating summons or notice of appeal is the spinal cord of the criminal matter. It is the foundation upon which all other processes and proceedings are hinged on the criminal matter. In other words, all other processes and proceedings trace their paternity and validity from the regulating process. The charge information hearing, it follows that the charge information which cries for survival gave birth to all the other processes filed by feuding parties and the proceedings in the action which transfigured into the appeal. Given this judicial relationship, the incompetence of the charge information pollutes the purity of the other processes and proceedings, inclusive of the judgment and ipso facto render them incompetent. The reason is obvious: they have no legal parentage to pledge and command their legality. And of course, this line of decision of the Supreme Court has been followed in plethora of authorities even before the 2025 decision of the state of Nigeria. By this, the Supreme Court stated that the criminal trial commenced on the basis of a charge not signed by an officer or prosecutor was incompetent and renders the entire proceedings in nullity, as only a competent charge can confer jurisdiction on the trial court. This is also the position of the state and state of Sabagi, which have the same facts but distinct as the state versus Nigeria, as in criminal appeals. For those of us who are familiar with cases like SBL Consortium, First Bank, and Miwada, it is the same reasoning of the Supreme Court in those line of decisions that the Supreme Court adopted in this case of state versus Nigeria to emphasize that failure to sign a charge by a prosecutor can be raised at any time and automatically does what? Nullifies the proceedings. I go to the next aspect of my paper, which is arrest, detention, and extrajudicial statement. Under this section, I'm going to dwell more with respect on extrajudicial statement. And that's what we try this. Extrajudicial statements in criminal proceedings. The next step of the trial process raises an evidential stronghold, which is the treatment of extrajudicial statements. The law is settled that statements made outside the courtroom, particularly those of witnesses, are generally inadmissible, except for the narrow purposes of contradiction or impeachment. This safeguard prevents the prosecution from viewing a case of hearsay or untested account and enforces the importance of sworn testimony given in open court, subject to cross-examination. I refer to the case of 2025 case of INR FR. Simply put, an extrajudicial statement is any statement made outside the four walls of the court. Because such statements are not made on oath and are not subject to cross-examination, the general rule is that they are inadmissible. And of course, this line of authorities is in line with the Supreme Court decision as far back as the case of Ezangedu and the state. In this aspect, we have been consistent. The rationale is clear, which is that the court can only act on the sworn testimony tested without cross-examination. The Court of Appeal considered this principle located on states observing that admissible evidence is what the witness gives on oath in open court, not what is said in the police station or elsewhere before the trial. That said, the position is not uniform across the board. Whether an extrajudicial statement can be used depends on who made the statement. Whether the maker is the accused person, the prosecution often seeks to tell lies, particularly if it contains a confession. On the other hand, the defense may rely on the extrajudicial statement of a prosecution witness, but only where it contradicts that witness' sworn testimony. This raises an important question, which is whether a statement made by a suspect during police investigation, whether confession or not, be treated as an extrajudicial statement. Nigerian courts have consistently answered this in the affirmative. Such trial statements are indeed extrajudicial because they are made outside court and without the sanction of an oath. Mr. Referee made this point expressly while the Supreme Court, the Caribbean of the state, affirmed that the confessional statement recorded by the police is nothing but an extrajudicial statement. Now, the next part of the paper I want to dwell on is on the issue of confessional statement or admissibility of confessional statement invoking the provisions of Section 15 and 17 of the Administration of Criminal Justice Act. In the course of the year, the Supreme Court had chalked out several decisions, and those decisions are simply to the effect that recording of the process of taking a statement of an accused person is mandatory, thereby interpreting the use of the word may to mean shall in the context of those provisions. And some school of thought have welcomed that decision to say yes, it is not overrated, particularly taking into consideration the experience and the course of the investigation in the hands of the police. And I also noticed that in my previous papers, I've held the view that that provision should be interpreted as shall, following what the Supreme Court held in the line of cases of Ejiofor and the state and Aclrc and the state. But in a deeper reflection of those line of decisions today, I came to I'm of the opinion that it shouldn't be a general rule now. It should be a case-by-case approach. And I'm not oblivious of the fact that the police in the course of the investigation, not only the police, the EFCC in the course of the investigation do all sorts to extract confessional statements from defendants. But the point remains that if we adopt strictly the position of the Supreme Court in line of those decisions, I think it's going to create more problems for us. And why do I say so? A lot of defense attorneys, of course, I'm not leaving myself out of it, are glad that the Supreme Court have given such line of decisions, and as such we can raise that objection to say, my Lord, rejects this document, it is not admissible, it was not voluntary. But the truth is that we also have instances where indeed that confession was actually voluntary. It was voluntary, but hiding under the cover of the provisions of Section 15 and 17, those line of statements would have to be expunged from evidence. And I think that with respect will not indeed serve the cause of justice. As we all know, as held by my Lord Buta, justice is a two-way traffic. It is not only for the prosecution, it is also for the defendant, and it is also for the public who is observing the proceedings. So I just thought I should not share this thought before I read out what I have on this position. Now, the most evidential portion, however, arises with respect to confessional statements of accused person. On this one, I show that both the law counts out the major exception. That is why the extrajudicial statements of witnesses are generally inadmissible. The confessional statement of an accused person is where voluntary form the basis of a conviction. The Aclrc in sections 15 and 17 introduce procedural safeguards designed to modernize the process, such as electronic recording and the presence of counsel. Yes, as recent decisions like FIR and Ejiofor, like I mentioned, and FIR and Aclrc illustrate the judicial interpretation of these safeguards, has created its own challenges which run the risk of elevating procedure over substance. Now, the Administration of Criminal Justice Act introduced a carefully structured means for the taking and admissibility of professional statements. The law recognizes, on the other hand, the need to safeguard the right of suspects during the delicate process of interrogation, and on the other hand, the importance of ensuring that voluntary oral admissions to guilt are not excluded merely on account of procedural formality. Section 15.4 of the Aclrc provides to the effect that where a suspect, when arrested with or without the warrant for the to make a professional statement, the police officer shall ensure that such a statement is reduced into writing. In furtherance of transparency and accountability, the subsection also contemplates the use of technology and stability that the process will be recorded electronically on the viewable video compact disc or such other audio-visual means. The evidence legislature is to discourage oppressive practices or preserve the integrity of the investigative process and to provide a reliable record for the court to examine the event of the dispute around voluntariness. The law, however, stops short of making electronic record a mandatory constitution for admissibility. Section 15.5 expressly provides that notwithstanding subsection 4, an oral confession shall be admissible in evidence. This saving clause is significant. It demonstrates that the draftsman deliberately chose not to fetter the discretion of the court or to cripple criminal investigations in situations where technological facilities are not available. The operating body, notwithstanding, makes it clear that oral confessions retain the evidential value provided that the court is satisfied as to their voluntariness and reliability. Section 15.5 of the Administration of Criminal Justice Act 2015 is unambiguous in its preservation of oral confessions and admissible evidence. The subsection provides that notwithstanding the electronic record requirement under Section 15, an oral confession remains admissible in evidence. In practical terms, this means that investigating police officers who directly receive such oral admissions can testify to them in court, and such testimony constitute direct, primary evidence. Moreover, the Supreme Court has recently repeated, affirmed that oral confession attracts no less evidential weight than written confessions. I refer us to Bala COB, where my Lord ABUJA, in a comprehensive review of both written and oral confessions tells us, it is settled now that the oral confession of an accused person carries equal weight as one made in writing, and is admissible and becomes part of the evidence, which the court will consider to determine whether the accused person is or is not guilty of offense with which he is charged. Similarly, in one of the states, his lordship GSC further emphasized that the law is that an oral confession carries no less weight than one made in writing. It is an admission by conduct. This is to say with respect that this judicialism is consistent with long-standing evidential principles, that what matters is the voluntariness and credibility of the confession, and certainly not the medium through which it is expressed, which has indeed now become the new normal as per Section 15.4 and Supreme Court decisions are identified above. The argument that may be raised by proponents of rigid observance of Section 15.4 is that oral confessions attested to by police investigators constitute hearsay under the Evidence Act, which will be conceived both in law and logic. An investigative police officer who directly interrogated the suspect and had the confession will be testifying to facts within his personal knowledge, and such evidence will not be hearsay by any stretch of the Evidence Act. See Section 37. And I also refer us to the case of Aclrc versus State, where my Lord Justice Uwashile was held that when a witness gives account of information of what he hears directly from another person, the information cannot be termed as hearsay. This position was definitely settled in Bala versus COP, where the Supreme Court upheld the testimony of investigating police officers who recounted the defendant's oral confessions made during the interrogation. The court was emphatic that the evidence was admissible as it was not challenged and capable of binding the conviction. And I quote what my Lord said this. In the instant case, the respondent relied on both the conventional statement of the applicant and the circumstantial evidence present in the testimonies of the three prosecution witnesses. The records of appeal show that apart from the extrajudicial confidential statement of the applicants in writing, which was tendered as Exhibit D, the second and third prosecution witnesses, the investigating police officers who interrogated the applicant at two different police stations, gave evidence that the applicant made oral statements admitting the commission of offenses during the interrogation. The third prosecution witnesses testified that the applicant and his co-accused that the two machetes that they used in killing the deceased person were in their house as Bala paid, and that they followed them to the location and recovered the two cutlasses. The two cutlasses were tendered in evidence. The evidence of the second and third prosecution witness was not challenged, discredited, or disparaged under cross-examination. Now, therefore, I also further refer to the case of Oregon versus the States, where recreating the same position. Therefore, the law recognizes the practical realities of police investigation, which is that oral confessions are made in real time in the presence of investigators, often before any formal process of writing or recording can commence. To treat such evidence as inadmissible or other that requires recording will be contrary to the operational realities of policing in Nigeria. Now, this is the point. I earlier said that there's this strict application of section 15 and 17 to throughout confessional statements. I don't think it's over yet, despite the decision of the Supreme Court. If for any reason, and this is my view, and I'm expressing this view based on the consistent decisions, a plethora of decisions of the Supreme Court to the point, which is the fact that oral confessions of an accused or a defendant carries no less weight than that of a written confession. Is that you find yourself in such a situation because, as we all know, during the course of the investigation by the police, the situation is usually the defendant stating their own side of the story. And in that situation, if there's any confession, of course, they must have related that oral confession to the police before it is put in writing. I'm of the view strongly that evidence of an investigating officer recounting what the defendant told them in the course of the investigation is admissible for the purpose of the confession made by the defendant, even in a situation whereby that statement has been adjudged to be inadmissible for not complying with the provisions of section 15 and 17 of the Administration of Criminal Justice Act. Judicial position. The Court of Appeal in Samaila versus the State, where it examined the requirement of section 15 and 17 of the Act just stated thus. The quotation is there. For want of time, I won't dwell much on that. I think I'll just go to the thought of the rigid interpretation. A careful examination of the reasoning in Aclrc case reveals certain troubled consequences that flow from the judicial approach adopted there. The first relates to the undeniably technological deficit of the Nigerian police force. It is a matter of common knowledge that the police across most parts of the Federation lack the facilities for universal electronic recording of suspect statements. To insist, therefore, that admissibility of a confession is contingent upon electronic recording is to impose a burden that the institution is structurally incapable of bearing. The inevitable result will be the paralysis of criminal investigations and the exclusion of confessional evidence that may otherwise be credible, thereby fracturing the ability of prosecutors to secure convictions in cases where justice so demands. The second concern is a subtle but real encroachment on legislative powers and the distortion of legislative intents. Sections 15 and 17 of the AJA and the wisdom of the adjustment employ the permissive term may rather than the obligatory shall. In the cadence of statutory interpretation, may conveys discretion, not compulsion. It appears that the legislature, conscious of our structural limitations, intended these provisions to be aspirational and progressive in nature, gradually steering the criminal process toward modern standards, but without shutting out confessions obtained under less than ideal conditions. By construing may as shall, the Supreme Court has with respect substituted its own policy preference for that of the Parliament, which is by strict letters of the Constitution saddled with the duties of lawmaking. The third and final concern is the neglect of the saving clause contained in section 15.5 of the AJA, which explicitly preserves the admissibility of oral confessions, notwithstanding the provisions of subsection 4. This clause is not incidental. It was deliberately inserted to assure courts that confessions once shown to be voluntary remain admissible, even if not electronically recorded. To disregard this saving clause is to strip the statute of one of its most critical balancing features and to deny effect to the plain words of the legislature. Argument for a case-by-case approach. And please, this is just my thought, it's my own personal opinion on this. To my mind, a proper reading of section 15.5 of the AJA makes one thing abundantly clear, which is that the admissibility of the confessional statement must continue to be determined on a case-by-case basis, with voluntariness as decisive criteria. The law has never adopted a mechanical approach to confessions, and nothing in sections 15 or 17 suggests that the legislature intended to alter that settled position. Rather, the evaluation of confessions should remain grounded in the traditional trial of voluntariness, the availability or opportunity for legal representation, and corroboration, whether direct or circumstantial. This flexible but principled approach aligns with the realities of Nigeria's investigative architecture. It preserves fairness for the accused while maintaining the functional capacity of our prosecutorial institutions. It also provides an avenue for judges to exercise judicial activism responsibly when necessary. As a member of my Lord Oputa JSC, as he then was, usually remind us in the case of Josiah versus the state. I think we all know what that principle is, which clearly settles that justice is a two-way traffic. Accordingly, confessions that may not strictly comply with sections 15 and 17 should not be discarded automatically. Once the court is satisfied that such a confession is direct, positive, voluntary, and consistent with credible supporting evidence, it ought to be admitted and relied upon. To insist on rigid compliance in all circumstances, particularly in a country where police stations across many states still lack basic recording facilities, will result in grave injustice and frustrate the administration of criminal justice. Countless cases, including those predating the ACTA, will collapse under a technical burden the legislature itself never intended. And I relied on the position of my Lord Justice, Professor Wade GSC, in the case of Tade Buntoyibo versus FRN, and this is what he said. I perfectly agree with the learned trial judge, not only on the permissiveness of the provisions of section, is a court of appeal decision, but also the portion of section 15.4, which says the taking of a statement which shall be in writing may be recorded electronically or retrievable video compact disc or such other audio-visual means. I think to his credit, the draftsman of the ACTA has carefully and deliberately used the word shall and may, sometimes in the same text, to pointedly make a distinction between statements that are mandatory and those that are permissive. The ACTA, being a technological enterprise, dexterously mixes the command word shall with the permissive word may for textual accomplishment. This, to my mind, recognition of the fact that the ACTA is largely legislation in the realm of the ideal, containing provisions that are presently enforceable and those that can only hope for enforcement in the near future. Very important. All, however, are geared towards fulfilling its grand purpose, ensuring efficient management of criminal justice institutions, speedy dispensation of justice, protection of society, and safeguarding the rights of suspects, defendants, and victims. Mandatory words impose a duty, permissive words grant discretion. Now, I have deliberately referred to this part of the decision just to underscore my point that some of those provisions in the ACTA, of course, section 15 and 17 inclusive, no, particular section 15, some of those provisions there are with the current infrastructure we have. It's not, there are things that we may not be able to achieve at this particular time. That is why I have brought that out to underscore that point. And of course, as I said, I'm aware that there are plethora of Supreme Court decisions saying that the requirements in those provisions are mandatory. But I think we should also be, in making some of those decisions, we should also be realistic as to what the position is now. Another area relating to section 15.4 of ACTA is the danger of synthetic media to auto-visual recording of confessions. And I've said that furthermore, while section 15.4 ACTA encourages electronic recording of confessional statements, strict insistence on video or audio recordings in the present technological climate may prove counterproductive. The world is now struggling with synthetic media, which is defined as a highly realistic artificial audio, video, and image content generated using artificial intelligence, commonly referred as deepfakes. Synthetic media are capable of fabricating voices, faces, and entire confessional scenarios with dangerous precision. The fundamental question I want to ask is that let us be realistic with ourselves. Do we really have the state of our laws? Can it really accommodate or address some of the challenges that will arise as a result of synthetic media? The answer is certainly no. And this is just to further underscore the point that in every situation, it should be a case-by-case approach. It should not just be a blanket application of that provision. Given that Nigeria or any other country for that matter as of now does not yet possess reliable forensic tools to distinguish genuine recordings from deepfakes, and obsessive insistence on electronic recording as the only credible proof of voluntariness as required under Section 15.4 and the cases under reference could inadvertently weaken prosecution efforts and foster wrongful allegation for fabrication. Until the requisite technology and expertise are widely available, the courts must continue to apply the long-standing test of voluntariness, supported by corroborative evidence whether or not a confession is electronically documented. My next sub is bail pending trial and the violation of defendant's bail by state actors. I'll just say in summary that there's actually nothing new about the law of bail. There's really nothing new about the law of bail. The courts in the past year have been consistent in applying the provisions of the law in granting this discretionary in favor of, I'll just go to the emerging arguments that I think that has arose or that arises for the grant of bail, which is, I have that on page 16 of my paper. Research has shown that there remains no comprehensive statutory or judicial framework addressing certain circumstances where a defendant's non-appearance is caused by factors completely outside his control. For instance, when he is being hospitalized or incapacitated, being unlawfully detained by another agency, being prevented from attending court due to threats, violence, or interference by state operatives, or being displaced or forced to flee due to credible threats to life arising from the actions of state agents. Although courts have recognized that the defendant should not be penalized for absence caused by circumstances outside his control, the law provides no clear procedural guidance for distinguishing deliberate absconding from unavoidable absence. This uncertainty can unfairly penalize defendants and sureties, particularly where the state itself contributes to or causes the absence. Closely related are the increasing report of custodial institutions refusing to honor bail orders and instead choosing to detain defendants arbitrarily. Such conduct effectively nullifies the court's decisions, offends the principle of separation of powers, and undermines the integrity of bail as a constitutional safeguard. These gaps highlight the need for stronger statutory protections and more assertive judicial oversight. A worrisome recent trend in bail practice is the routine remand of the defendants, even after bail has been granted, simply because they have not immediately satisfied the bail conditions. You will see someone or a defendant who came from their houses to court for arraignment being whisked to correctional centers, even upon being granted bail. This development undermines the very rationale of bail and amounts in substance to the trial punishment. In my considered view, the more rational and constitutionally compliant approach is for courts to allow for a reasonable timeline, even until the next adjourned date. For the defendant to know the bail conditions, this practice will drastically reduce the population of awaiting trials, inmates in correctional centers, and ensure that bail retains its meaning as a safeguard of liberty. Is not merely theoretical, especially if the offense in question is bailable and the defendant is still presumed innocent under Section 36(5) of the Constitution. There is no constitutional or statutory basis for keeping him in custody merely because administrative steps in the bail process are yet to be concluded. There is no gainsaying that the law governing bail has not changed. As I said earlier, bail remains a right, not a privilege. Courts should therefore resist practices that convert that right into a punishment. And one worrying area that I think, of course, is a recurring guest now is the idea of defendants' process of investigation and investigating authorities have admitted them to bail on administrative bail. This same defendant goes to court for arraignment, on the administrative bail. And after they are granted bail but they are still being kept in the correctional center pending the time that they fulfill their bail condition. I think going forward, this really has to be looked at. I don't think we respect that the entirely defeats the purpose of bail. Or whether there are gaps in legislation or practice that require reform to better protect accused persons. Yes, the answer is yes. There are indeed visible gaps in both our laws and the application, which demand urgent reform if the rights of accused persons are to be truly protected. The Administration of Criminal Justice Act was widely hailed as a progressive step, but its great weakness has been in implementation. The recurring realities of unlawful arrest, prolonged child detention, and the abuse of remand procedures demonstrate that the spirit of the law has not yet been fully translated into practice. One of the emerging gaps in both legislation and practice concerns the use of technology in the commission of crime. Offenses such as cyber stalking, identity theft, financial fraud, and criminal defamation through anonymous or digitally manipulated content pose unprecedented evidentiary challenges, just like the synthetic media I mentioned earlier. For instance, in cases of online criminal defamation, where defamatory content has been created using anonymous accounts, VPN maxing, or synthetic media, establishing authorship or intent becomes significantly more difficult. Without robust digital forensics, traceability mechanisms, and statutory frameworks suited to 21st century realities, the criminal justice system risks being outpaced by the ingenuity and anonymity afforded by modern technologies. More importantly, without specialized digital forensic capabilities, the state may be unable to trace IP footage, decry communication trails, or authenticate multimedia evidence. This deficiency presents a real danger, that is, the criminal justice system risks becoming obsolete in the face of offenders who weaponize technology while remaining beyond the reach of law enforcement. And I think we do. I think it's actually becoming obsolete, particularly when it comes to investigation with the police. In the same vein, innocent persons could be wrongly implicated by deepfaked or manipulated content, thereby undermining the integrity of criminal prosecutions. This development highlights the urgent need for legislative and institutional reform. Nigeria must adopt clearer statutory standards for the admissibility and authentication of digital evidence. Courts must be empowered to assist on forensic verification of electronically sourced evidence. Law enforcement agencies must be equipped with modern investigative tools, including forensic laboratories and trained personnel, capable of decoding the complex, multi-layered architecture of digital crime. Without such reforms, the administration of criminal justice will remain reactive rather than proactive, leaving both society and the right of accused persons vulnerable to the difficulty of cyber-enabled criminality. Conclusion. Overall, the appellate courts in the past years have consolidated procedural safeguards for accused persons, decisions on charges, extrajudicial statements, and bill demonstrate a judicially committed to constitutional rights. However, the Supreme Court's rigid stance on confessional statement risks undermining the balance between rights protection and prosecutorial effectiveness. A more balanced case-by-case approach, as contemplated by Section 15 and 17 of ABUJA, is more sustainable. It respects legislative intent, acknowledges infrastructural limitations, and promotes justice as both principled and sustainable within the current technological realities in Nigeria. Thank you.
Thank you very much, Mr. Adedayo, Senior Advocate of Nigeria, for your paper, which has been well delivered. I am sure we took down some points while he was delivering his paper. So opportunity will be afforded every one of us to make some comments. Surely I have some comments to make. We will just quickly now invite our discussants and Mr. Habib Auredola, do we have you ready?
Evening, sir.
Senior Advocate of Nigeria, you are ready? All right. So can you just shift to me? So you are to take the floor virtually right now. So I
Thank
give
you
the
very
virtual
much.
floor to you. Thank you.
May I respectfully stand on all existing protocol? However, may I state that it's a privilege to share this platform today with the eminent erudite scholar S.T. Horn, Senior Advocate of Nigeria. We thank you profusely for your contribution to the jurisprudence of law, particularly in the area of evidence. We're most grateful. May I also recognize and thank the organizers for extending the invites to me, particularly our father, our leader, our mentor, Mr. J.B. DAUDU, SAN. Permit me also to acknowledge distinguished retired Justice M.A. Auredola, my very own father. I'm happy to see you this morning. Eminent Senior Advocate of Nigeria and learned colleagues, I respectfully again stand on existing protocol. Perhaps I would share the paper I intend to discuss briefly this morning. I'll be speaking. Can I have confirmation that the paper is visible? I would assume it is. I'll be speaking this morning on the defense of insanity in Nigeria, criminal jurisprudence, a critical analysis of the case of Mohammed versus the state.
Sorry, let me see if you have just 10 minutes to summarize your opinion, sir.
I will. I'll do my best in summarizing the paper in 10 minutes. And PT Aliu Suleiman versus Nigerian Army. This paper is titled When Justice Fails to Meet the Afflicted Mind. I begin with the concerned proposition that our criminal justice system in its current form is structurally incapable of distinguishing between the genuinely insane and the cunningly deceptive. This is not a hyperbole. It's a conclusion drawn from careful examination of several decided cases. A classical example is a case which I personally handled of Private Aliu Suleiman versus Nigerian Army. Private Aliu Suleiman was in detention for over 22 years. And on appeal to the Court of Appeal Lagos, the Court of Appeal held the finding and sentence of death of the General Court Martial pronounced on the appellant PT Aliu Suleiman on 21st June 2000 is hereby set aside. In the place of the said finding and sentence, I order that the appellant be kept in a mental institution until his rehabilitation. In brief, the finding at the court martial was set aside, and within a period of 2 months, he was reintegrated into the society and back to his family. Now, this is after he had spent about 22 years in prison. I would also like to briefly consider the case of Sanusi Mohammed versus the state, the recent decision of the Supreme Court. In this appeal, the appellant was charged with the offense of culpable homicide punishable with death. The appellant's brother testified that he had taken him twice to a psychiatric hospital in 2001. The year the offense occurred. The appellant's fellow prison inmates also described his behavior, which is consistent with severe mental disorder. DW2 precisely testified that when he was brought to the prison, he was stripped naked, attacking other inmates at night. In addition to the avalanche of circumstantial evidence available on the record of the court, The appellant's outpatient card from a psychiatric facility was also tendered in evidence. Interestingly, the appellant was convicted and sentenced to death despite the avalanche of circumstantial evidence to establish mental insanity. The Supreme Court, in affirming this conviction, made findings that reveals that the defense of insanity had not been established, not because the evidence was evaluated and found wanting in credibility, but largely because the Supreme Court held that the defense failed to present medical evidence in the form of a doctor's testimony or comprehensive psychiatric report. This case exemplifies a fundamental systemic vacuum at the intersection of law, medicine, and justice, as I have adumbrated in the case of P.T. Suleiman versus Nigerian Army. It is a lacuna and the path towards remediation that forms the subject of today's discourse. The basic provision, because of time, I will simply summarize some provisions so I can get to the recommendations. The basic provisions of our law that regulates the defense of insanity is Section 28 of the Criminal Code and Section 51 of the Penal Code. Now, analyzing critically the case of Mohammed versus the state and the testimony that abounds, what it seeks, it appears the Supreme Court respectfully did, was to state or place huge emphasis on the availability of medical evidence, which is a very tall burden of proof in the circumstance to establish insanity. The trial high court simply concluded that there is no direct evidence which shows that at the time of the commission of the offense, the accused was out of his mind and did not know the nature of what he was doing. The Court of Appeal, while more thorough in its analysis, essentially agreed. The Supreme Court also agreed. Now, let us examine the Supreme Court's reasoning with the critical eye it deserves. Regarding the testimony of DW1, there was evidence on record that the appellant in that case had been a patient at the psychiatric hospital between January to March 2001. However, this testimony was not taken into account in reaching a final decision. As for the testimony of DW2, the testimony of an inmate in prison, it was dismissed as a mere prison inmate and questioned why the prison inmates did not bring it to the attention of the prison authorities. It is also quite concerning at this point to state that the court held the testimony of DW2 has no evidential value in establishing mental state of the appellant at the time he committed the act or even after. Let us pause here. Section 28 of the Criminal Code and 51 of the Penal Code establish that the relevant inquiry is the accused's mental state at the time of the offense. But how does one prove a state of mind at the moment in the past? Inevitably, circumstantial evidence, through circumstantial evidence of behavior before, during, and after the act. The court's wholesale dismissal of evidence of post-offense behavior as having no evidential value is therefore respectfully wrong. It makes the defense of insanity virtually impossible to establish. May I also state that I find some contradictory findings from the decision of the court when he held that, in quote, Medical evidence is desirable in proof of insanity, especially where the accused has sought to rely on it, but it is not essential or necessary. The court states medical evidence is not essential, then effectively requires it by finding all non-medical circumstantial evidence insufficient. The court faulted the defense of failing to establish Mohammed's mental state precisely at the time of the offense in December 2001. DW1's testimony placed psychiatric treatment in January and April 2001. However, leaving the period from April to December unexplained. What this reasoning imposes is an impossible burden with the greatest respect. Mental illness is not like a light switch. To require evidence of mental incapacity at the exact moment the criminal act is to require the impossible, particularly for defendants who lack continuous psychiatric care. This takes us to the next point, the impracticability of establishing temporal precision. In the case of Mohammed versus the state, what we saw is the Supreme Court did not place reliance on circumstantial evidence. The court wanted evidence of Mohammed's mental state in December 2001, but rejected evidence from April 2001 by DW1, perhaps as being too early, and evidence from his time after the offense, perhaps as being too late to establish a state of mind during the offense. This temporal precision requirement by medical evidence make the defense practically impossible to establish in cases where the accused is not under continuous psychiatric observation at the time of the offense. I must state that for the various nomenclature and categorization of different types of insanity, this is a vanishingly rare circumstance. This will be my recommendation. One is legislative reforms. We need to modernize statutory language. The criminal code and penal code should be amended to replace archaic terms like unsoundness of mind and natural mental infirmity with modern psychiatric terminology. And the reason is because our current laws as it relates to the defense of mental insanity, it is predicated on the Magnatin Rule of 1843 in England. May I also respectfully mention that in other Commonwealth jurisdictions where these principles or rules were developed, they have since evolved and amended their laws to reflect modern research in clinical psychology as it relates to insanity being a defense to an offense. From my research, may I also suggest that we consider a two-stage trial system when insanity is raised. Stage one will be to determine whether the accused committed the offense for which he was charged, and stage two will be if he has committed the offense, there should be a separate hearing on criminal responsibility, including consideration of insanity or diminished responsibility. This prevents the confusion that currently exists when judges must simultaneously assess whether the accused is afflicted with any form of mental delusion or insanity. May I also recommend that there are judicial trainings on this program. And finally, my recommendation will be that as legal practitioners, we should adopt proactive approach. In the decision of the Court of Appeal in PTE Suleiman, let me see if I can share. On appeal, I had taken a relatively different approach by approaching the Court of Appeal that the decision of the court-martial should be set aside and that the appellant should not be remanded at the pleasure of the governor. However, what I had sought is that he should be released and integrated into the society upon being certified by qualified medical practitioner. This is not the provision of the Act. And at the Court of Appeal, I had argued that in my view, I am convinced this would be the justice of the case for someone who is afflicted by mental delusion, insanity, and has been in prison for 21 years. To further detain him at the pleasure of the president or pending his release will be double jeopardy in my view. And thankfully, the Court of Appeal agreed with our argument and held and allowed the conviction of the court-martial was set aside and the appellant was subjected to immediate release into the society pending certification by 2 medical practitioners. And I'm happy to say that he's been safely back to his family now. In conclusion, some of the reforms I have proposed today simply reflect established best practices from comparable common law jurisdiction. They are eminently practicable. What they require is the will to acknowledge that our current system fails the genuinely mentally ill persons. Every year, Nigerian justice system processes thousands of defendants. A fraction of them suffers genuine mental illness that should preclude criminal responsibility. Under our current system, most of these individuals will be convicted and imprisoned without any meaningful consideration of their mental states. Equally disturbing is that persons with serious mental illness are kept in correctional facilities with normal convicts. How can the convicts become reformed in such circumstance? For instance, if half or more of the inmates are suffering from severe mental illness. This, in my respectful view, is a moral crisis hiding in plain sight. Thank you very much. May I also finally, may I thank the organizers for providing such a platform to express very critical and important view. Thank you very much.
Thank you very much, Nancy. Well, this first round of applause is accolade for delivering the paper brilliantly. But now, he made some proposals. The proposals are very proactive. Again, they are very brilliant proposals, which I hope this forum will take very seriously. And for that too, I want us to give him a round of applause. So it is my honor to call on Chinelo Ofo-Egunam, Esquire. We are still in the virtual world, so I am still inviting her to take the virtual floor over there. Let's hear her. A round of applause for Ashley. Are you ready, Chinelo? Is Chinelo available?
Good morning, distinguished gentlemen of the Innoba and the Altoba. I must particularly appreciate you all again for inviting me for yet another conference. I've listened in from the onset. I I wasn't opportune to join in the first, the second, and the third day, but I'm happy I was able to listen in today. And thank you very much to the lead presenter and the other presenter for your wondrous industry to the paper. So I'll just go right into it. My topic today is basically on the offense of wandering. Now, the definition simply means moving about without a clear purpose or destination, often raising suspicion about one's intention. I have a case with particular reference to Abu and the states. That is what I was asked to work on. So in this particular case, I have actually gone ahead to talk about the facts of the case, the issues. I'm sure the organizers have my paper already. So with this particular case, wandering was defined as a ramble without a definite purpose or objective, to roam, rove, or to stray, or to go aimlessly, indirectly, or casually to minor relevant legislations and all. Also, on page 327, paragraph A to D, it was held that at common law, the freedom to roam or everyone's right is the general public's right to access certain public or private owned land, lakes or rivers for recreation and exercise. The right is sometimes called the right of public access to the wilderness or the right to roam. Now, in modern times, the offense has been criticized for being overly broad and susceptible to abuse, potentially infringing on individuals' rights to freedom of movement and association. Again, our Constitution guarantees these rights, and courts are increasingly expected to balance public interest with individual liberties. Now, given the evolving nature of social values and human rights, it's possible that courts may reassess the relevance and application of the offense of wandering, considering factors like personal freedom, public safety, and the need for clear definitions of criminal conduct. So now the offense of wandering is in common law the same as vagrancy. The vagrancy law in this jurisdiction and some jurisdictions was created to criminalize the act of wandering from place to place with no evidence of employment or a way to support oneself, prostitution, professional gambling, and disorderly conduct, loitering, public intoxication, and public defecation or urination were also regarded as acts of vagrancy. Now, vagrancy and wandering was originally a crime targeted at homelessness and unemployment that was overreachingly and subjectively used to arrest those seen as political opponents or troublemakers. Most crimes which were covered by the law of vagrancy now have individual charges targeted at the specific offense. We have sections 167 to 169 of the Criminal Code, sections 140 to 142, and sections 306 of the Penal Code of Northern Nigeria. Now, what are the key legal considerations? The vagueness and due process. Now, generic wandering statuses are often found unconstitutional because they fail to provide clear notice of what conduct is prohibited and allow for arbitrary enforcement by police. We also have statutes against conduct. Now, modern laws generally must criminalize specific conduct with a criminal intent, that's the mens rea and the actus rea, rather than a person's status, for example, being unemployed or homeless. And we also have the protected activities, which laws cannot prohibit legal behavior, such as window shopping, waiting for a friend around the corner, or engaging in political speech, which may involve wandering or remaining in a public space. Now, in summary, the offense of wandering is best understood in the context of these specific examples, narrowing defined modern statutes that require proof of specific criminal intent and related actions rather than the simple act of moving about without a clear destination. Now, the case Abu and the States, 2005, 7 Nigerian Criminal Law Reports, Part 1989, page 299. The case summary, the issue basically was whether the Court of Appeal was right in affirming the conviction and sentence of the appellant for the 2 count offenses of criminal conspiracy to commit armed robbery and belonging to a wandering gang or persons associated for the purpose of habitually committing armed robbery. In fact, the appellant alongside 5 others were arraigned at the High Court of Gombe State on 3 count charges of criminal conspiracy to commit armed robbery, contrary to Section 5B of the punishable under Section 12B of the Robbery and Firearm Special Provisions Act. Illegal possession of firearms punishable under Section 3 of the Robber and Firearms Special Provisions Act, and belonging to the wandering gang of persons associated with the purpose of habitually committing armed robbery punishable under Section 306 of the Penal Code. The appellants and others were alleged to have conspired to rob a certain today market in Gombe while in possession of pistol with 4 rounds of live ammunition without a license. The appellant pleaded not guilty to a 3 count charge preferred against him. The respondent, in proof of its case, called 6 witnesses while the appellant testified in his defense. As before, at the end of the trial, the appellant was convicted on 2 of the counts. He was discharged and acquitted on the 2nd count, charge of illegal possession of firearms. Now, dissatisfied with this judgment of the trial court, the appellants appealed to the Court of Appeal, which dismissed the appeal and affirmed the judgment of the trial court. Still dissatisfied with this decision of the Court of Appeal, the appellant appealed to the Supreme Court. Now, in determining the appeal, the Supreme Court considered the provisions of Section 2.3 of the Robbery and Firearms Special Provisions Act, Section 218 of the Criminal Procedure Code, and Section 306 of the Penal Code. I don't think it's necessary for me to go into the sections, but I'll just read that of Section 306 of the Penal Code, which says that whoever belongs to a wandering or other gang of persons associated for the purpose of habitually committing theft or robbery and not being a gang of bandits shall be punished with imprisonment for a term which may extend to 7 years and shall also be liable to fine. After all said and done, it was held and defined that wandering is amountable to rambling around. Now, the court's reasoning on the offense of wandering, now there's a notable pronouncement in that judgment on the need to expunge wandering as an offense from the Penal Code and the Criminal Code. Now, per Ogun Major JSC, at pages 327 to 328, paragraph F to C, held that by way of obita, I think the law against wandering has lost its relevance and it's against the spirit and letters of the 1999 Constitution of the Federal Republic of Nigeria's altar. However, I will not go as far as to hold the law unconstitutional and to strike it down or expunge it from the Penal Code of Northern Nigeria or the Criminal Code of Southern Nigeria. Most states still have this law in their criminal law codes. This is principally because this court has not been asked to do by the appellant's counsel, and so the court will not graciously strike out the criminal legislation. Apart from that, the whole essence of the society is to set limits to the rights of individuals if and when they infringe on the rights of the corporate unit. Thus, Chapter 4 of the 1999 Constitution, in setting out these fundamental rights, makes them subordinate to the overall good of the society, and accordingly enables laws that are necessary for democracy, security, and the general well-being of the entire society. It appears that, as William Pitt stated at the House of Commons speech in 1783, necessity is the plea of every infringement of human freedom. It is the arguments of tyrants. It is the creed of slaves. The court has the unique duty to deal with the human rights when infringed by government or the executive or another private individual. It is the reconciliation of liberty with authority that is thus the burden duty of all judges. And the implications for this law is that it's being found in a public place. Being found in a public place is the key ingredient of this offense. Since the available evidence, the appellant's confessional statement show that they were found in an uncompleted building and not in a public place. The ingredients of being found in a public place was not proved. Now, what's the relevance in present-day society as stipulated in my letter? Now, it's overly broad. The definition raises concerns as to abuse of power. It infringes on the right of freedom of movement, our Constitution again, Section 41. To prove the commission of the offense in Section 2.3 of the Robbery and Firearms Special Provision Act, evidence must exist showing that where the appellants were found is a public place. Now, modern perspectives, the offense of wandering and vagrancy is largely considered irrelevant in modern society because most forms have been repealed and invalidated by courts as unconstitutional. Historically, it's used to criticize poverty, homelessness, and other undesirable populations. Current laws generally focus on specific criminal acts rather than a person's economic status or transient status. Instead of vagrancy laws, societies now rely on laws against loitering, trespassing, public order offenses, while addressing homelessness through social services and mental health initiatives. We also have balancing public interest with individual liberties. Now, there is need for clear definitions of criminal conduct because if we look at criminalization versus social issue, the consensus today is that wandering due to homelessness is not a crime itself, but a social issue that requires social solutions. Criminalizing it is seen as counterproductive, leading to a cycle of arrests, fines, increased barriers to employment and housing for the individuals involved. The implications that you need clearer definitions and stricter proof requirements, and then courts must balance public safety with individual liberties. And in conclusion, wandering offense requires reassessment in the light of modern human rights and societal values. The case of Abu and State highlights the need for careful application. Law reforms and clarity are essential to ensure just application. However, in discussing the lead presenter's paper and to lend my voice and have a bite at it as well, now, further to emphasize that the recent trends and key cases in Nigerian criminal law and procedure and evidence appellate courts are: 1, proof of intent. The Court of Appeal in Abu and States 2005-7 Nigerian citation provided emphasizes the importance of proving intent in criminal cases, highlighting the need for clear evidence to establish mens rea. Here, say evidence. The Supreme Court in State and Ibrahim, again, citation provided, reaffirmed the principles governing hearsay evidence, stressing the importance of adhering to Evidence Act provisions. See also Issa and State as given to us by the lead presenter. Confessional statements. In Okonkwo and the States, citation provided, the Court of Appeal provided guidance on the admissibility and the weight of confessional statements, emphasizing the need for voluntariness and collaboration, but for the exception, as rightly stated by PA, JFC, Halilu, and Katsina states. Citation provided. Now, we also have the issue of synthetic media evidence. I also believe that cases should be treated on a case-to-case basis, as the second presenter stated. Sadly, because as a country, we are not properly equipped to handle the use cases of AI. We are a work in progress, but until we have all the angles in place, we don't need to get swamped with the intricacies surrounding it. Now, the emerging issues, digital evidence, the increasing use of digital evidence in criminal trials have raised questions about admissibility and authentication. Recent decisions such as State and Adewale have begun to address these issues. Plea bargaining. The Court of Appeal in State and Uche explored the role of plea bargaining in the Nigerian criminal justice, highlighting the need for transparency and fairness. Admissibility of facts not otherwise relevant, as stated by the lead presenter. Section 4 and 5 of the Evidence Act stipulates what is relevant, and cases abound, such as the Diamond Bank and Aclrc case, and also the EFCC and Diamond Bank PLC citation provided. Also, in the Ayaka and State
one minute more.
Case, citation provided, facts not otherwise relevant are relevant if they are inconsistent with any fact in issue or relevant facts, or if by themselves or in connection with other facts they make the existence or non-existence of any facts in issue or relevant facts probable or improbable. See also Section 9A of the Evidence Act. Now, takeaways. I recommend strict adherence to procedure, as recent decisions emphasize the importance of following established procedures and the rules of evidence. Evidence-based prosecution. Prosecution must rely on credible, admissible evidence to secure convictions. And judicial activism. The appellate courts are increasingly taking a more proactive role in ensuring justice is served while maintaining the rule of law. So I can confirm that that there's been an improvement from the last conference to this time. And I want to appreciate again the organizers of this ruler conference, seeing me worthy to take a bite at the conversations during the conference. I think it's a good place to stop now. Thank you very much.
Thank you very much. Let's give her a round of applause, even for going outside the scope of her paper. Now, Barachu Dangana is here with us. So we are back home. Are you the first one, please? Ten minutes.
May I use this opportunity to thank the convener of the Rule of Law Development Foundation Conference for this great privilege to participate in the session and in the conference, and to give my thoughts on this outstanding topic that deals with our criminal justice in Nigeria. May I also thank my noble Lord for the privilege and permit me to lean on the existing established protocol. Now, I am to look at the topic, Nigerian Criminal Law and Procedure Evidence Annual Survey of the Appellate Court decision, with a focus on what role can civil society and human rights organizations play in monitoring and advocating for fair trial standards. Now, the simple introduction is that fairness in trial or judicial process is vital for social engineering. Every progressive society needs a fair trial standard for trials. And the beacon of such fairness in trial is embedded in fair trial standards, whereby processes and procedures laid down by law are duly observed by all justice stakeholders in ensuring that justice is both done and seen to have been done according to law. Either before trial, just as the two lead presenters have presented, or during trial, and even post-trial, such as we have heard even within the week, dealing with the correctional service. Now, there are some definition of terms, but basically I will look at the specification of human rights organizations, civil society. Civil society organizations are made up of people and organizations that work voluntarily to promote shared interests, hold government accountable, improve society without seeking political power. And these are the bodies that majorly put pressure in the society and on the government to ensure that fairness is ensured in trial. And human rights organizations are also institutions that promote and protect and defend the fundamental rights and freedoms of individuals and communities. Now, these organizations have basic roles to monitor human rights violation, advocate for justice, provide legal aid to victims, and raise awareness, among other things. Now, basically, I'll go directly to, there are frameworks that regulate the role of the civil society and human rights organizations in Nigeria to ensure fair trial standards. Now, some of these frameworks, or the major framework, is our own constitution. And if you check section 35 and section 36, these fair trial standards of our country are embedded in those sections, together with the sections that deals with fundamental rights of citizens. So I won't go into the frameworks, they are listed there. I would like to begin by listing out the fair trial standards for which these CSOs and HROs, that is civil society organizations and human rights organizations, are to focus on while monitoring and advocating for fair trial standards. Now, the first right I will look at here is right to a competent, independent and impartial tribunal or court. Now, this right is very, very important. It is contained in section 36(1) of the 1999 Constitution. In the recent case of Dela Dibala and COP, the lead presenters have presented this case also. One thing that strikes there concerning this fair trial standard is that the trial of the accused person is not looked at by the court at the investigation stage, but at the moment of arraignment before the court. In that decision, the trial of an accused person commences on arraignment and taking his plea. So the right to fair hearing will commence from the time an accused person is brought before the court and his plea is taken. The period does not include the pretrial stage, to which the period covering the time he was arrested to the time he was arraigned in court and his plea is taken. This was the decision of the Apex Court. Now, I move quickly to presumption of innocence. Every accused person is presumed innocent. So, civil societies in their monitoring and advocacy roles are to also ensure that they push for these fair trial standards to be embedded in our criminal justice system. Now, in the Supreme Court case, reiterated the fair trial standard of presumption of innocence in a recent case of Hafizu against the state, where it was held that it is not the responsibility of the defendant to prove his innocence, except when he alleges existence of certain facts which he must prove, but a bounded duty on the state to prove the guilt of the accused person beyond reasonable doubt. Now, right to public hearing. Trials should be conducted in open courts, and the media should also be allowed to see what happens. This is embedded in section 36 of 4A and B of our Constitution, right to be informed of the charges. Now, usually this right is taken for granted mostly. An accused person or a defendant is arrested and he doesn't know the reason why he is arrested. But it is a fair trial standard that our civil society should pressure on, that every person who is accused must be told why he is. Every person who is arrested must be told why he is arrested and the offense for which he is arrested. Section 36 of 6A of our Constitution provided for that. Right to adequate time and facility to prepare a defense is also a fair trial standard right that should be advocated by our civil society to ensure justice in the criminal justice sector of our nation. Now, this right is supported by Section 36 sub B of the Constitution, Federal Republic of Nigeria. Now, right to facility to prepare defense. The defendant has the right under the fair trial standard to be given facility to prepare his defense. Section 36 sub 6B. The Supreme Court has in recent decision in the case of the same Dela Dibala against COP whereby Aclrc SC had this to say that Section 36 of B only comes into play after the charges have been preferred and accused person has pleaded to the charge. Now, even then, it is not automatic and has to be applied for. That is the facilities for which the defendant should use for his defense should not be given automatically to the defendant unless he applied for it. Basic point here is that not attaching proof of evidence to a charge or information does not invalidate the charge or the fair trial standard. The defendant must apply for such facility before the court, as a right is set to be automatic. Now, facilities should be requested after arraignment when court is seized with jurisdiction, not before arraignment. Now, one wonders why the court held it not to be automatic when it is a constitutional provision for fair trial standard. Right to legal representation. The defendant has a right under fair trial standards to a lawyer of his own choosing. If the defendant does not have a lawyer, the court is even empowered, especially in cases, perhaps capital offenses, to give a lawyer that, to give to that defendant or accused person a lawyer to defend him. Now, in the recent case of Abiodun Bamiboye versus COP, a criminal charge that was a criminal case that was filed before the inferior court, this question of right to legal representation came for determination. And the court has this to say: the right of the appellant to choose legal practitioner to represent remains extant, but he has chosen a legal practitioner who is disabled from representing the appellant because the forum is an inferior court, that is a magistrate court. Such denial of right of audience to Mr. Olumide Fusika, SAN, is not tantamount to denial of fair hearing to the appellant. Now, the poser. The rules of privileges and functions of the senior advocate of 1979 were used in deciding this case. Between the Constitution, Federal Republic of Nigeria, Section 36(6) of C, and the Senior Advocates of Nigeria privileges and function rules, which should take priority in considering especially Section 1, Sub 1 and 3 of the Constitution. Right to examine witnesses and evidence. This is also a right. In the case of Ilyasu against the Kano State government, the court, in deciding if prosecution is to tender evidence, that is, tender all extrajudicial statements of the accused, whether they are favorable or unfavorable to the accused person, in the course of investigation, held that non-tendering of such extrajudicial statements can be escalated to become withholding evidence only if the defendant accused must have made a demand for it from the prosecution and it was refused. That idea of withholding evidence makes the evidence incriminating, and so it should be used in favor of the accused. Now, the same issue was mentioned in the case of Baba Nana Abubakar Mohammed versus the state. The Supreme Court restated the law that the defendant has the fundamental right to cross-examine witness produced by the prosecution, either himself or by counsel. I think in that case, the counsel did not cross-examine the witness, and they raised it up on appeal. Right to an interpreter. If the defendant accused does not understand the language used in the court, he has a right to a competent interpreter. Section 36 of 6E. Right against self-incrimination. Now, this is where we have a lot of issues, and the pressure groups of the CSOs and the HROs should also put more pressure on this, even though this has to do with also the safeguard provided in ACJA, which has also been discussed this morning, Section 15 and Section 17 of the ACJA. Now, Section 36 of 11 of our Constitution said, any statement that is obtained through coercion provided for this right. And the basic theme is that a statement that is obtained through coercion or torture of the defendant is inadmissible in evidence, leading to trial within trial. Now, confessions obtained through inducement are also inadmissible under Section 29 of the Evidence Act. But we look forward to a day when forensic evidence devoid of any confession will grant conviction in our courts. I think this is also one of the roles that judicial CSOs and HROs should ensure right to trial without undue delay. Now, our criminal justice system is very, very guilty of trials with delay. On Monday, when we started this conference, the Honorable Minister gave us a data of the inmates in our prisons, and above 50%, I think it's above 60%, he reported are awaiting trial. And perhaps many of these are awaiting trial, not just for a year or for two, but for many years. Right to undue delay is a fair trial standard embedded in Section 36 of our Constitution, and we should, our CSOs and HROs should ensure that there should be trial within time. Right to appeal is also another fair trial standard right. In criminal cases, there must be a right to review the conviction and sentence before a higher tribunal if the person decides to exercise that right. Right against double jeopardy. No one should be tried or punished twice is a fair trial standard embedded in our Constitution. In the recent case of Shuaib Chiroma against the state, reported in 2025, it was made clear that an accused cannot be tried twice for the same offense. The Supreme Court relied on the rationale in the American case of Green versus United States that the state, with all its powers, should not be allowed to make repeated attempts to convict an individual on an alleged offense. The court, however, made it clear that an order for a trial or a new trial is binding and do not constitute double jeopardy. So, having known the fair trial standards, what should the CSOs and the HROs do in ensuring that these fair trial standards are applied and ensured in our criminal prosecution? The monitoring of the trials is one of those ways, wherein they send observers to monitor how trials are conducted, putting into consideration the required standards, and report any irregularity. Now, they do that in order to ensure justice for the society, which includes the victim and the defendant accused of the crime. Advocacy is one of those roles that civil societies can advocate for policy changes and legislative and law reforms to strengthen fair trial standard guarantees through engagement of stakeholders of criminal justice administration at all levels. Engaging with government is another way CSOs and HROs aid in ensuring fair trial when they dialogue with government officials to push for fair trial reforms. For instance, the United Nations International Children's Emergency Fund have been in serious dialogue and advocacy with government agencies, including Ministry of Justice of various states, to ensure fair trial standards for children, and that even in criminal procedure involving children, the welfare of the children is paramount in pre-trial, during trial, and as well as post-trial stages. Capacity building and empowerment is one of those responsibilities of civil societies and human rights organizations. And this particular criminal law review conference is one of such capacity building in fulfillment of those roles wherein civil societies and human rights organizations ensure that the society that they represent are empowered with knowledge to be able to ensure fair trial and fair trial standards are followed in our criminal justice system. Public awareness, educating the populace is one of those roles. Supporting the victims, providing legal aid is one of those roles that civil society can play to ensure they give the legal criminal justice support and the legal aid is given to victims of human rights abuses and can help ensure their rights are protected and defended in line with fair trial standards. Reporting is one of those roles civil society play. It's another functions that they perform wherein they publish reports on fair trial issues and recommendations for improvements. For instance, CSOs like Amnesty International give yearly report of human rights violation and other human rights issues affecting citizens. And another role that civil societies should play and can play is researching. CSOs can conduct research on the effectiveness of certain laws in achieving the reasons for enacting their reforms. Now, finally, I conclude by recommending that With the current situation of justice sector and delay in reaching conclusion in cases lying in the dockets of many courts, civil societies and human rights organizations should have to exert more pressure on authorities to develop with options of sanction a time frame for criminal cases pending before various courts. For instance, there should be penalty for a judge or a prosecutor who refused to prosecute or conduct trial within a maximum of 2 years after arraignment. This will assist in decongesting the correctional centers involved in post-trial, pre-trial, and there won't be justice denial, which is justice delay. And then the recent increments, and also within our justice sector, I believe that there should be an increase of justices at various levels. In 1999, our population was said to have been 123 million Nigerians. Now we are over 237 million Nigerians. We need more justices, both at the Court of Appeal and at the Supreme Court, to deal with the constant outflow of cases that stay in the docket of some of our superior courts for 5-10 years without hearing. I conclude by also saying that the recent increments in filing fee at the Supreme Court should also be looked at by CSOs, because access to justice is also a fair trial standard. If the people and the populace that the civil society organizations are standing for cannot access justice, then justice is said to have been denied. Thank you for giving me this opportunity.
Thank you very much, Aclrc. Please, let's give her another round of applause for a good job done. And the last, but not the least discussant, is Chinelo Obuzo Anarado, Esquire. Let's give a round.
Good afternoon, everyone.
10 minutes, Chinelo.
Yes, sir. Good afternoon, Mr. DAUDU. Thank you for the opportunity. Please permit me to stand on the protocol already established. I am happy to be the last discussant. The good thing about being the last discussant for a topic this serious is that I get to have the advantage of hiding behind every other person. And so I say that I adopt every submission that has been made, especially by my guy, my boss in chambers, Mr. Adedeji, Senior Advocate of Nigeria. I will only appeal to him, sir, that when it comes to these advantages which we have made under sections 15.5 and 17.2 of the ACJA, you should please leave it for us like that. The reason being that we cannot play hanky-panky with the police. If the Supreme Court can decide on a panel of 5 justices that a lot has happened in the past and we should make progress, I think we should all not remind them that they can actually find a way out of these situations. And the truth is, the police is now complying. It is easier for the police to make a budget for compliance with those provisions than for us to give them exceptions. Once we give the police exceptions, they will make it the general rule and we'll be back to step 1 again. The other point I was going to make on that issue is that the provision for 15.4 and 17.2 are actually different. While 15.4 is limited to confessional statements, that means that for you to insist that there must be electronic recording, it has to be that the statement, the extrajudicial statement itself is confessional in nature. If it is not, then that provision does not apply. You will land under 17.2. And under 17.2, it is not only electronic evidence recording that is required. It can be written statements, and all that is required is that there should be another person where that statement is made. So I feel like this rule is relaxed. It is completely relaxed and we should not relax it any further. Then the other question is whether any lawyer here will allow their clients, who is the defendant, to admit that he made any form of oral confession to any police officer that is not recorded anywhere in the world. I don't think that. I think that's why the police is not even relying on that provision, because they know any evidence that is, any statement that is made under such circumstances will never see the light of the day. I also want to talk about what the Supreme Court said, held in Aclrc, FRN and Aclrc 2024, 12 Nigerian Weekly Law Reports, part 1951, page 1. And His Lordship Agim Jesse held that the experience in most cases is that arrested suspects disagree with the assurances that were made when they were making their statements, and that they start to contest the voluntariness of those statements, and that these provisions that have now come under ACJ is an intervention that saves the time of the courts from going into trial within trial, so that the judges don't even have to waste their time anymore. All you need to hear is that there was no recording, and if there was no recording, simple and short, this evidence is inadmissible, we make progress. And I think that is progressive. In the other authority I also want to talk about is FRN and Kano, which was discussed on Tuesday, but another aspect of it. What happened here? The defendant was on bail, and while he was during the pendency of his bail, he was at home, and his home was invaded by the military, and he fled and ran away from the country. And the prosecution went to the court and informed the court that the man had jumped bail. And based on that, process of extradition started, and eventually it was rendition and he was brought back to the country. And when the trial started, when he was brought back into the country, he raised an objection that the trial should not continue because the process with which he was brought to court, it was illegal. And the Supreme Court said, no, well, you must face your trial. But then IDJSC made very serious remarks, and he went to the roots of the issue of jumping bail. And what my lord said there was that if you go and interfere with a man's bail in a nature that he has to fear for his life, and then he takes off, he takes flight, you cannot accuse that man of having jumped bail. And that the prosecution acted in bad faith. Yes, thank you, sir. In bad faith, when they misled the court, that the man had jumped bail, when they knew it was their actions that caused him to flee, and that it was reasonable for a man who was standing trial for treason to suspect that the military invading his home illegally, that they were coming to kill him, so that he ran for his life, and that formed the foundation of the extradition and all the other processes that continued. So I think this will be an authority for instances where people are granted bail and the prosecution interferes with their bail and then goes back to court to say that they jumped bail. I think the Supreme Court making comments on this point is very crucial. Then on the only authority which was given to this panel, which I think we have not touched on, which I want to address briefly, is the authority of Sunday Jackson and the states. Now, if you type Sunday Jackson on your internet now, you will see so many things. People abusing the Nigerian Supreme Court for what they deem to be an unjust decision of a farmer who went to his farm and he was attacked, and he killed his assailant, and they found him guilty of murder. Now, what happened? Sunday Jackson went to his farm sometime in January 2015. He was not in his farm from the decision of the court. He said he had gone to the bush to fetch grass, and that he was accosted by this cattle rearer who some rustlers had taken away his cow, killed the cow, and he was pursuing them, and then he lost sight of them. Then he ran into Sunday Jackson, and out of his frustration, he attacked Sunday, and Sunday retaliated. Both of them got into a fight. He disarmed the man, and he stabbed him 3 times on the leg, and the man died. Now, when he was arrested, Sonny Jackson made a confessional statement. And after he made that confessional statement, the matter was charged to court. When he got to court, he then tried to change his to rescind from his confessional statement. Now saying that, oh, this confessional statement was not voluntarily made. The court adjourned for trial within trial. On the day of that trial within trial, his lawyer came to court and said that they were withdrawing their objection. And so, when the time for defense came, he entered into the box and changed his statements that he made to the police, and now gave a different account of what happened. The trial court found that his confessional statement was still binding on him, and that what he said in court was an afterthought. The Court of Appeal upheld that, and the Supreme Court further upheld that decision. Now, let me, if the chairman will permit me, let me just read out my thoughts, how I've put it. I said the guiding principle of self-defense is that the victim of an unprovoked attack by an aggressor reserves the right to defend himself from assault by the application of such force as may be necessary and proportionate to neutralize the aggressor and save himself. It means, therefore, that to successfully plead self-defense to a murder charge, the defendant must satisfy the court that the action he took, which led to the death of the deceased, was the only available option to save his own life. Hence, the defendant must not be found to have had any other opportunity or alternative that could have spared both his own life and that of the deceased. It need be emphasized that the sanctity of human life is considered paramount, such that the right to life is extended even to aggressors until otherwise is proven. When the defendant to a murder charge raises self-defense, the court must be satisfied with evidence that the defendant acted in defense and not in vengeance. However, in some cases, the line between defense and vengeance is too narrow that a defendant may slip into a murder conviction by applying a little more force, no matter how little the force. In the assessment of whether a defendant applied reasonable or excessive force in neutralizing an aggressor turned disease, each case is determined on its own merits. Hence, what may be considered excessive in case A may be reasonable in case B. In Jackson's case, upon his arrest by the police, he volunteered an extrajudicial statement narrating the incident that led to the killing of the deceased as follows. On Tuesday, 27/1/15, about 11:10 hours, I left my village and was cutting thatching grasses in a bush located in Kodomti village in Numan local government area, where the deceased, Alhaji Buba Bauru, was identified, attacked me after losing sight of some persons alleged to be pursuing for killing his cattle. He attacked me in frustration and wanted to stab me with a dagger. Then we engaged in a wrestling encounter. I succeeded in seizing the dagger from him, which I used to stab him thrice on his throat. When the deceased collapsed and was rolling down in pool of his blood, I took heels and escaped. My facing cap and sickle fell down at the scene. I stabbed him on the throat twice with intention to kill him. This was what he said to the police. Now, at his trial, the defense raised an objection to the voluntariness of the above statements. However, on the date set for trial within trial, the same defense, without reason, withdrew the objection, causing the court to admit the statements in evidence as Exhibit B and B1 and B2. The appellant's failure to challenge the voluntariness of his extrajudicial statement appeared to have been the singular factor that changed the trajectory of his case. As court after court considered his statement to be confessional, Jackson would eventually testify in his own defense, where he narrated a different account of the events of that day as follows. I went to my farm. I was walking. One Fulani man rushing with his cattle. Then he asked me that there are some people that came through there. Where are they? I answered that I don't know. Then he put his cattle into my farm. Then I asked him, why did he put his cattle into my farm? He did not say anything. Then I pursued the cattle out of my farm. From there, he brought out a knife, advancing towards me with the knife. I have nothing in my hand. I started running and shouting. No one came out as I was running. He stabbed me with the knife on the back of my head. I turned to hit him with my leg. Then he stabbed me with the knife on my leg. At that time, I got scared. When he tried to stab me again, I held his hand and we were struggling. I collected the knife. Then he picked a stick. As he beat me, I stabbed him at the point he could not beat me again. He was weak. I threw away the knife there and went back home. This is what happened. Now, a very different account from the first. The trial court as well as the appellate court rejected Jackson's second narration of the killing, concluding saying to be an afterthought. The appellant, having neither challenged his earlier confessional statement already in evidence as Exhibit B1 and B2, nor explained the vital inconsistencies in his second account. The court were therefore left with the decision whether or not Jackson's extrajudicial statement presented an exercise of his right to self-defense against the disease. At this juncture, it is important to identify the inconsistencies in Jackson's accounts of the murder. Although in both narrations, Jackson did not provoke the attack, the venues of the attack are strikingly different. In the first narration, Jackson was fetching thatching grasses in a bush, whereas in the second account, he was in his farm when the deceased trespassed with his cattle, destroying Jackson's crops. The vital point here is that while in his confessional statement, there was no attack on Jackson's property to warrant his defense of property, in the second account, he had his farm to protect. Further, in the first account, during the attack, Jackson wrestled the weapon from the aggressor, therefore neutralized the aggressor and removing the occasion of imminent danger of harm before proceeding to stab him on the neck, not once, not twice, but thrice. Interestingly, in the second narration, the aggressor attacked him with a weapon. He, Jackson, attempted to run but was caught by the aggressor, who stabbed him twice on the back of his head and on his left leg. Jackson then managed to disarm the aggressor, but rather than flee, the aggressor continued to beat him with his stick. That is another weapon now introduced. Therefore, in the face of continued assault by the aggressor, Jackson had no other choice than to stab him in the neck. The trial court examined appellant's body, that's Jackson's body, found that there was indeed a scar on the back of his head and another scar on his left leg, but concluded that the appellant failed to lead any further evidence that both wounds were inflicted on him by the deceased during the attack. The court held further that the appellant did not present medical reports of his injuries. The evidence presented in court is clear that the attack on the appellant was not witnessed by any other person. Therefore, I am curious how the medical reports demanded by the court could have resolved the question of how Jackson's injuries were sustained. The point being made is that the medical personnel who would have made the medical report would be unable to answer the question who inflicted the injuries, whether it was Alhaji Bauro or was the man himself that stabbed himself so that he could have his defense. The question that comes to mind therefore is, would the court have found in Jackson's favor that Exhibit B1 and B2 did not meet the requirements of a confession had Jackson proved that the stab wounds were sustained from the actions of the deceased, presenting independent evidence of another established fact which is inconsistent with the confession, or did the portion of Jackson's oral evidence where he stated that he was stabbed by the deceased contrary to his earlier extrajudicial statement? A further question is, although one cannot predict whether or not the trial court would have upheld Jackson's objection to the voluntariness of his extrajudicial statement, would the court have reached a different verdict had the defense successfully eliminated Exhibit B1 and B2 from the records, leaving the court with Jackson's oral evidence only? By Jackson's second account of the narration, the elements of necessity and proportion appeared established. Necessity because he was under attack by an aggressor who was aiming to kill him, having inflicted grievous bodily harm by stabbing him. And proportion because there was no other alternative to neutralize the continued assault by the aggressor. Unfortunately for Jackson, the majority of the Supreme Court, 4-1, did not consider the facts as presented in his second narration for reasons of saying being an afterthought. The court specifically said that the appellant was trying to perform an 11th hour miracle with his testimony. In their evaluation of the degree of force applied by the appellant to neutralize his aggressor, 3 different opinions emerged from the 5-man panel of the Supreme Court as follows. Ogumiji JSC, who dissented, held, the deceased here was a trespasser on the land of the appellant. I believe the misapprehension of the land of the 2 lower courts in finding the appellant guilty because he did not run away after he gained the upper hand is from the unwarranted and unreasonable interpretation of the need for the person attacked to disengage no matter the circumstances. I do appreciate the point that vengefulness or excessiveness in the defense of the right to life must not be encouraged. I can find no vengefulness in the action of the appellant. I'm of the view that the defense of self-defense avails the appellant and his response was not excessive. I acquit and discharge the appellant. Agin JSC held, where a person successfully wrestles and disarms the other person that had come to stab him, took over the dagger but did not escape or retreat after seizing the dagger, and used same to stab the now unarmed assailant twice on the throat, killing him. The stabs on the assailant clearly amount to reprisal or revenge attacks and not acts of self-defense or provocation. Samani JSC was of the view that the appellant inflicted more harm than was necessary for the purpose of defending himself. Having overpowered the deceased and collected the dagger from him, a stab would not be considered excessive. So in Samani JSC's view, 1 would have been enough, but 3 was too much, even if that one had killed him. Idris JSC held, it is clear from the statement of the appellant that there was no reasonable mode of escape by retreat, and there was no necessity to take the life of the deceased. So another opinion, he could not have run, but he should not have killed him. Nothing best explains the narrow lines between reasonable and excessive force in the exercise of the right to self-defense than the above opinions of the eminent jurists of the Supreme Court, who could not reach a unanimous decision on the acceptable degree of force expected of the appellant in this case. It would appear that the appellant may have had a stronger case had he left the deceased only 1 stab. In the leading judgment of the court, like the biblical pilots, the Supreme Court, seeing the unfortunate situation of the appellant, sought other ways to explain his predicament, when it sought to raise and weigh the possibility of the defense of provocation, whether it could avail him as follows. In another light, the mind of this court is clouded with the thought of, if the defense of self-defense raised by the appellant does not avail him, can the defense of provocation suffice to mitigate the conviction and sentence of the appellant? The question is born out of the duty of this court in all trials of culpable homicide to consider all defenses raised by the defense, even if the accused person specifically put up such defense or not. It is clear that the deceased incited the appellant by attacking him in frustration, and he wanted to stab him with a dagger. They engaged in a fight. This is suggestive of provocation. The appellant stated in his statement that he succeeded in seizing the dagger from the deceased and used it to stab him twice on his throat. I understand that he lost his self-control, which prompted his stabbing the deceased. Maybe if it was once, I would have been fine. But stabbing him twice was over the top. I hope that the defense of provocation also fails. Also, by way of addition, and still bearing my findings in mind, it is important to state that even though the appellant raised the defense of self-defense at the trial court, which was also considered in the court below, and that this court raised the defense of provocation, a defense which it takes its elements presented itself from the evidence on record, but which it has now come to the conclusion does not avail the appellant. Both defenses of self-defense and provocation are mutually exclusive and cannot avail the appellant in this case. Well, the court concluded that he was guilty and that his conviction would stand. Ogumiji JSC eventually made an appeal to the governor of Adamawa State that prerogative of mercy should be exercised in his favor. they've told me that my time is up, so I will hold my other opinions. Thank you very much.
Thank you very much, Chinelo. Okay. I know if you had the whole day, you will have carried on. Your analysis has been so exquisite, and I'm sure it will provoke some discussion there. Unfortunately, Ogunwumeju was alone in her plea for prerogative of mercy. All right, thank you. And this brings us to an end our discussions, which I know our session has been very exciting, and a lot of discussion will be provoked. I will, before I yield the floor to everyone here, first for those who are here physically, and next, those who are online. I want to request the IT woman, please can you post one picture there for us, for a discussion. All right, so my intervention, I have two. Yes, and in respect of Mr. Dedeji's submission, which Chinelo actually also commented on. You see, I thought that with the decision of the Supreme Court in Nigeria 4 and FRN, that this position about the electronic recording of confessional statement, that the matter had been settled. Well, I know even at the Supreme Court we have conflicting judgments over the matter. But the point I am making is Nigeria 4, being the latest in time, I suppose should be taken as representing the position of the law. That is one. Then number two, there are pronouncements of the Supreme Court in that case that will also appear to have put finality on that issue. For instance, I want to quote just very briefly statements made by Okoro JSC and Ogunwumeju JSC. In the opinion of Okoro JSC, he explained that since the law has provided for a suspect extrajudicial statement to be electronically recorded in the presence of a legal practitioner of his choice, it will amount to a violation of the law if that provision is not followed to the letter. You know, that was a pronouncement coming from the Apex Court, that it will amount to a violation of the law if that provision is not followed to the letter. Then Ogunwumeju also made her own contribution, and very powerfully too, to say that the essence of video and audio-visual evidence is obviously so that the court will be able to decipher from the demeanor of the defendant and all other surrounding circumstances. All other surrounding circumstances in the video, if he or she voluntarily made the confessional statement. Alternatively, where video, okay, she went on to say, however, over the years, it seems to me that these provisions are only existent on paper as the police. As the police and other security agencies seldom comply with them. The current state of technology, that's the point I want to make here. Because Mr. Dedeji complained about the state of affairs, the state of technology, the level we are in. That matter too had been pronounced upon by the Supreme Court. As far as the Supreme Court is concerned, the level of our technology today is sufficient to make that provision to be mandatory. You know, now the current state of technology, where most mobile phones have a recording application that will state the time and place of making the video, if there is no official police photographer at hand, makes the non-compliance inexcusable. My lords, it is baffling, to say the least, that at this point in our criminal justice system, there is still failure to meet the minimum standards of police investigation or interrogation that obtains in other jurisdictions. So in essence, Ogun-Ijesi is saying that we have no excuse not to make that provision mandatory. And what is really going to be our excuse? Is it because we don't have money to buy phones for our policemen to carry out this function of what? And I want to believe too, there is hardly any village, if any hamlet today, that will not receive internet service. At least we have sufficient service that will enable you to make phone calls and make recordings. So that is my intervention about that. Then, please, let's see the picture here. Mr. Adedeji made a very valid point in respect of what the court is facing or what court is likely to face in the face of technological development. You see this picture, I'm sure it looks like me somehow. Yes. What happened is that somebody, a lecturer in the National Open University, I was in Lokoja at the weekend when he called me and said he wrote a book and requested me to launch it for him. Then I said I was going to buy 2 copies. So then he sent me his account details, and I sent the little I had, to him. Only for him later to send this picture to me. This is the book that he wrote, and which I was supposed to have launched, in that manner. There was me and him never met, and there was in fact, up to now, I've not even gone to school to see this book, but you can see me here, that I was holding a book and I was launching it. So if this evidence is brought before the court, now what will happen? So that is one of the greatest challenges that we have in technology. This is what we call deepfake. And we have so many of these all around going on. So I want to say here that it's a challenge to the court, and we are facing how to handle it. Authentication of electronically generated evidence, authentication of, this is AI generated. So how do we authenticate AI generated documents? So he raised the issue in his paper, and I think it's a valid point that we really have to look into. So in other climes, I know there are legislative interventions, but here in Nigeria, we know we don't allow our law, to move at the pace of technology. So it is not just a challenge to the court, it is also a challenge to the legislature. And we have been clamoring, for instance, even for ordinary electronic transaction legislation to be made. Up till now, it has not been made. So as we progress, we are going to be facing more of these challenges. Thank you very much. I want to yield the floor to anyone who wants to contribute. Like I said, we have had an exciting time, very powerful lectures and papers. Yes, learned safe.
Yes, my first question is to Mr. Oredola. I want to commend him. He talked about the McNaughton rules, and I just wanted to clarify whether by his paper he's saying that the McNaughton rules as a rule is now obsolete, given that it is still the position in the United Kingdom for findings of not guilty by reason of insanity, and whether he feels the concept of diminished responsibility, which is a common law principle in practice in the UK, can also help with issues of transient incapacity, especially in cases of homicide, whether the concept of diminished responsibility, which is not codified in Nigeria, can be used. Then I wanted to ask Mr. Horn, and he has left. There is a new form of jurisprudence coming up in our courts with regards to bail. Some courts are now taking the position that bail is now a post-arraignment application. I want to ask, in view of the extant provisions of Section 158 of our Administration of Criminal Justice Act, is this the position of the law, whether if you file a motion for bail when your client has been charged and has not been arraigned, whether that application is competent? Those are my two questions. Thank you.
All right, thank you very much. Do we have any other intervention here before we go to Lokoja? All right. IG woman, can you take us to Lokoja now? Let's hear from them. All right, let's hear one person here. Yes?
Good afternoon, sir. My name is Abdul.
Just 1 minute.
My name is Abdul Malik Ahmed Zarouk. My question is directed to Leonard Seluk, lead presenter. Your position as to sections 15 and 17 of Aclrc. You've maintained the position that we should not deploy that in provisions to have like wide or broad application to admissibility of confessional statements, given the fact that oral confessions also are judicially admissible, despite the fact that maybe they are not subjected to the same safeguards in section 17 and 15 of Aclrc. Now, in cases where the Supreme Court has held that oral confessions are admissible, they usually hinge their decision and their reasoning on the fact that the defendant failed to cross-examine the IPO or the witness recounting the oral confession in court. And we know that when there is evidence and it is not challenged or uncontroverted by the defendant who is present in court, the court will take that evidence as admitted. And I think that plays like a decisive role in courts coming to the conclusion that oral confessions in those instances should be relied upon. So, but in confessional statements, there is a challenge, to those confessional statements, and that puts in issue the burden of the prosecution to now establish the voluntariness of the confessional statement. So, given these factors, can we maintain the position that the unchallenged evidence in oral confessions in court will make sections 15 and 17 to be inapplicable to oral confessional statement as opposed to confessional statement? Thank you, sir.
All right, thank you. Professor Lady, Doctor, you answer later. All right, so are we in Lokoja now? Okay, good. Do we have any intervention from Lokoja? Glass House, Government House, Lokoja. All right, thank you. Your worship.
My name is Ibrahim Denja Eleson. I am a chief magistrate. I preside over a chief magistrate court in Kogi State. I want to thank God for the opportunity to attend this exercise. In the first place, is a request that all these papers has not been made available to us. I think it's very important we have them. Then the second point, sir, that is worthy of being mentioned here is the issue as it deals with section 15.2 and 17.2. A lot of defendants are make away with, just as opined by the presenter, that something ordinarily has to be done by the issue of giving opportunities, although my Lord, the chairman of session, has given clarification as the Supreme Court, both in acts has dealt with it, that we do not have an excuse as the session has come to stay. The third comment or question that I want to actually bring up is regarding the issue of facility for, because I'm not very conversant with the names of the presenters. I want the presenter that spoke about issue of making available facilities for the defense, for the defendant in as a kind of a condition precedent, that who bears the cost? Because practical applications in our courts, a lot of people will come up, the defendant cannot be held responsible to bring up fund of making available funds for the prosecution to produce some of those evidences that are meant to be made to defend them. And another question that I want to quickly bring out, though outside the presentation here, is as it relates to section 84, section 4 of the Evidence Act. Thank God, my Lord, the chairman of session is a guru in that aspect. It's actually talking about certification. All this issue of electrically generated evidences, that recording or even some of those things or pictures that are taken from the scene of crime. A lot of problems are some of our courts that we need a further clarification as regard certificate of compliance. Certificate of compliance in our magistrate courts, though we know our courts is not like the High Court where the documents are front-loaded. Is it agreeable or applicable if the witness has given a clear explanation on how the court came about, the functionality of the camera or the gadget that was used for some of this recording, or the facilities that was used to take picture photograph? Since some of these analyses are what is contained in the certificate of compliance, the rest can stand before the court and give full detailed explanation of how they came about this. It can take the place of certificate of compliance. Please, I need clarification. Thank you so much, my Lord.
All right, thank you. Any other person from Lokoja?
Yes, sir. Chairman, sir, we question here.
Yes, Lokoja.
All right. My Lord, thank you for the opportunity. My name is Benjamin Obenege. I'm a lawyer with Kogi State Ministry of Justice, Lokoja. Sir, the Apex Court in Adeleke against Oyetola 2019 LPELR 46987 Supreme Court held that the requirement for admissibility of electronically generated evidence, particularly video recording, is the said video meets authenticity, reliability, and admissibility pursuant to Section 84 of the Evidence Act. Now, my question is that in our court here, particularly in the case I have participated in, we had the occasion to tender a video recording of a defendant who confessed to the commission of the crime, and the said video recording met an objection on the ground that a lawyer was not captured in the video while the confession was being made. Meanwhile, that is not part of the requirement for admissibility of that particular video evidence. So, my lords, I humbly urge you to throw some light on this particular issue, whether the presence of a lawyer pursuant to Section 17 of the ACJA is needed in the admissibility, in the tendering and admissibility of a video confession of a defendant. Thank you.
All right. Thank you very much. I will answer later.
Yes, sir. We still have it.
Oh, okay. Another
Yes, sir.
person in Lokoja.
No questions, sir. Yes, sir.
Answer that. Sorry, you will answer later. Yes, please.
Good afternoon, my lord.
Yes.
Recently, a colleague of mine sought to tender. My name is Amina Maji from Ministry of Justice. A colleague of mine sought to tender some computer-generated documents at the magistrate court, but defense raised an objection that he needed to tender them with the phone and the printer that was used in printing those pictures. Surprisingly, the magistrate upheld that objection. The documents were rejected. Yes, he's not here today. I knew he would have wanted to ask that question. So we need guidance on that. The magistrate rejected those documents because the phone and the printer with which they were made was not tendered in evidence. Thank you, my lord.
All right, thank you. Any other question?
Yes, sir, my lord. I think the last question we have, which borders on the bail of a defendant standing trial before a court. It has become an usual practice, my lord, in our trial courts these days that most especially EFCC-related criminal matters, that when a defendant is granted bail before a court, the court will now order that the prosecution verify the bail condition granted to the defendant before the defendant will be released. Unfortunately, it has been happening, and I think Mr. Osaje in Ali Peter's case took the matter up to Court of Appeal. Unfortunately, the Court of Appeal agreed with the trial court, who ordered that the police should verify the bail condition granted to the defendant before he could be released. We went from Court of Appeal to Supreme Court, and unfortunately, the Supreme Court sent us back that until the substantive trial is concluded, there is nothing that they don't want to hear us. We should go back and conclude the substantive trial. My concern, my lord, is that saying that a party or a party interested in the matter should verify the bail condition of the defendant, whereas when the bail was filed, a counter was filed to the effect that the bail should not be granted. Same party now is asked to verify the bail condition. Is it not a man being a judge in his or her own? I think it affects it goes to the constitutionality of our criminal jurisprudence, my lord. So the question the person asks here is that what is the legality or otherwise of such order by the court ordering the prosecution to verify the bail condition granted to the defendant? Thank you, my lord.
All right, thank you very much. So I'm sure that should be all now. That is all from Lokoja. Okay.
Yes, my lord.
Okay, thank you. Final question or contribution from Abuja here. Then we attempt to answer your question. I'm sure. Oh, okay. After him, he didn't tell. Please carry on.
All right. Thank you, my lord. My question is in reference to the last discussion. I think the discussion on that case and that issue could be expanded. Could we validly say that someone who is in danger of being killed is in a position to apply rationality in terms of how many stab wounds it would take to incapacitate the victim? Now, if we move beyond that to the facts of the matter, if we take as established the accounts of the appellant, the assailant in this case, was it established that he was on his farm when the incident happened? Is it established that there was some sort of altercation that resulted in the death of the deceased individual? And most importantly, what did the prosecution establish? So even listening to the account of what the appellant said, I think most people would lean towards the fact that he acted in self-defense. I mean, in saying this, I agree completely with the reasoning of the Supreme Court that when you give inconsistent accounts of what happened, then it's difficult to rely on the defense that you put forward. But is there a duty on the court to do justice in those situations, to look beyond what was presented by the accused person? I say this because recently when I read the decision of the English courts in the Ozekome trial, we see a situation where the judge even went beyond what was presented in court to even the obituaries that were published in Nigeria to reach a decision as to certain facts. So I'm just throwing questions in the air. I'm not making any conclusion since I can't argue with the Supreme Court. Thank you very much, sir.
All right, thank you very much. That case, actually, so many theories are embedded in it, and I wish you were part of the bench. Hearing you now asking that if somebody is being provoked, will he be rational enough, to take to know what to do or to know what is reasonable? That's a serious theory. Thank you, Mr. Agabi, Senior Advocate of Nigeria. So I allow the coordinator to take over.
Thank you very much, Mr. My Lord of this session. Although we have really stretched the time, but it's a very interesting session. I made a number of notes, but in between the question and answer and the contributions of other discussants, a lot of them have been dealt with. So I'll try and be very brief. Now, I'm worried about Mr. Didi GSA's position on oral confession, backed up as it is by a Supreme Court decision. My understanding is that when you take the law as a whole and not in segments, you cannot have an oral confession. Confession, by virtue of what it is a very serious indicting element or evidence against the defendant. And it has warranted the intervention of the state to introduce Section 15.4 and Section 17.2 as safeguards for the admissibility of confessional statements. Taking those ones alone, that is the safeguards in Section 15.4 going up to 17.2. It follows that there can be no such safeguards for oral confessions. That the intent of the law is that the confessional statement is a statement that was taken down in writing, videoed, in the presence of counsel of his choice or a social worker or somebody that is recognized by the statute. So the fact of the intervention of statute automatically, in my humble view, displaces the necessity or the admissibility of oral evidence. It can no longer arise. And why video evidence was required, and my Lord Joseph Gile will agree with me, that video evidence is considered as documentary evidence. So if video is what set down by statute to corroborate the sanity or sanctity of a confessional statement, it follows that what is being corroborated is that one that was in writing, and not a verbal discussion. Secondly, is that coming from the mouth of the IPU, and I don't think the Supreme Court really considered it, that evidence of somebody's conversation from his mouth is hearsay evidence. It is hearsay evidence in the sense that it is not coming from the mouth of the defendant himself. If the defendant had actually confessed, let him make a judicial confession before the judge. But for the IPU, who has an interest in the matter, whose interest is, then if you give room to that, every IPU will come and say that the accused person confessed to me without following the safeguards. And you make a caricature and mockery of the entire criminal trial and proceedings. Now there has been misconception in this issue of oral confession. Now he has cited Omorigwe against the state. That is the case in which, if my recollection serves me well, is the 1980s case. An IPU, a policeman was embedded in a prison cell with some dangerous criminals. And each person boasted of his own exploits. And being the man investigating the case of that suspected person, the man actually told his fellow criminals at that time, not knowing that it was a policeman, and explained step by step how he cleverly carried out that act. They then went and acted on the evidence and secured evidence. Before the court, he resigned from that position. The court did not treat it as oral confession, even at that stage. It was treated as evidence being elicited by deception. It was called detection by deception. That is the highest you can go with that kind of evidence. Because it will not fit in, my humble view, to section 28 of the Evidence Act 2011. Though it gives room, says admission or confession, did not say whether it's oral, but other things have now come to qualify it. I will leave every other one and just go to the Jackson issue. I must commend Chinelo for a thorough dissection of the case and presenting the options. I take my intervention is from this point. All the justices of the Supreme Court, not just 3 of them, approached the case from different angles, particularly the dissenting judgment that went head-on with affirming his innocence. I take the view flowing from my learned brother Siddiq position of the wider view of justice, especially in a situation where there is apprehension or risk to life, which has been confirmed. I take it, I submit, and strongly too, that the fact that 5 justices of the Supreme Court approached it in different manners. One even saying 1 star would have been sufficient, without factoring in what happens where there is a rush of adrenaline. Can you control those kind of chemical infections in the body? Now you have 5 different justices having different positions. My humble submission is that they should have treated their varying approaches as a doubt as to the guilt of the accused. And the law, because the Supreme Court is an extension, an appeal is an extension of the proceedings in the trial court. So by virtue of their provisions, I know whether it's 15 or 20 of the Supreme Court Act, they sit in the position of the trial court. Now, because their 5 minds are unable to agree on this point, I think on that basis they should have resolved the matter that there is reasonable doubt, and therefore it should result in the favor of the accused, the defendant. That's my intervention. Thank you.
Thank you. So, just 1 minute comment from our resource persons. I don't know whether Habib is around, Learning Silk. Habib is, no, I forgot to tell him to wait. So maybe he has gone. All right. So now, who else is there? What of, oh, Habib, just you are here when they were asking questions, making interventions. We just give you 1 minute to make your own comment.
Okay, so very briefly and in response to the question by the learned senior advocate, Mr. Paul DAUDU, SAN, what I said earlier, the 1843 McNaghten rule is still intact in the UK. However, they have focused on several key areas, such as graduated verdicts and flexible disposition, and then they have what they refer to as the regular review tribunals, which is a mental health review tribunal and conduct periodic assessment on detained person with a clear criteria for release. So there has been not necessarily modification to the laws, but the case law has evolved and relatively caught up with the advancement in medical research as it relates to the defense of insanity.
All right. Thank you very much. Chinelo Ofebuna, are you still around? Is Chinelo still there? The online Chinelo. All right. Okay. So I move to.
Yes, sir.
Oh, okay.
Hello, sir.
We give you just a minute to make your comment, if any. You are not bound to make one.
Okay. Since there are no questions directed to me, I'll just say, as we navigate through the complexities of Nigerian criminal law, let's just prioritize justice, fairness, and the protection of human rights. Thank you very much, my lord. Thank you very much, everyone that spoke on this matter, on this particular topic today. Thank you.
Okay. I come over to Mr. Adediji, Senior Advocate of Nigeria. Yes, I will call her.
Thank you very much, Mr. Chairman, for this opportunity.
I not meant if there were about 2 or 3 questions, yes. So I give you 2 minutes.
Okay. Thank you very much. Thank you very much. May I just start on the premise of first clarifying my thoughts on the issue of oral confession. And I'll start from the position of the Learned Silk, the coordinator of the Rule of Law Foundation. Contention that the testimony of an IPU is hearsay, I think we respect that there are quite a lot of authorities on the Supreme Court on that point, which clearly says that the testimony of an IPU is not hearsay. And the position I have made in respect of an oral confession is simply that if you are caught up with the issue of section 15 and 17, and I'm saying this from a practical perspective, having had the first-hand experience of it, is that the testimony of an IPU in the circumstance can actually be guarded. It is left for the court at that stage to decide whether that testimony, whether any weight whatsoever is going to be attached to it. So, my position is not that Section 15 and Section 17, as established by the Supreme Court, is the position of the law. That is the position of the law, no doubt about it. We are bound by it. I'm also aware of the fact that we have other decisions saying something else from the Supreme Court on this position. But of course, those line of authorities are the most recent and we're all bound by it. My position is simply that going forward, I strongly feel that we should also introduce a case-by-case approach to it, in applying this particular provision. And if caught up by this particular provision in applying it, that the testimony of an IPO of account of what transpired during the course of the investigation can actually pass as evidence of what the defendant told him. Because if we contend the respect that the testimony of an IPO is hearsay, we can as well say that there's no need for an IPO to come and testify, if that is the contention. So that is my response, or that is my thoughts on that. Further on the issue of, although that was not directed to me, but I think that was directed to Mr. Horn, but since he's not around, I'm going to address it on the issue of bail. Yes, exactly. I think I addressed that in my paper. If you read my paper, it is at page 16 and 17, and the position is quite clear. I've said it earlier, there's nothing new about the law of bail. On the issue of filing an application for bail, right, before arraignment, there's a difference between filing and taking an application, or arguing the application. Well, being an issue of discretion, those courts that has decided to contend that such an application is incompetent. I think for reasons best known to them, have decided maybe in exercising their discretion to say that. Sorry? Yes. Yeah, but what I'm saying in essence is that my response to that is that there's a difference between filing and arguing an application. And for the fact that you file a bail application before arraignment does not in itself make the application incompetent. Okay. Yeah. Then on the issue of the verification of bail conditions granted by the prosecution or the court, what is the legality otherwise? Well, my view on that is simple. Bail is discretionary. If the judge in his or her own wisdom thinks that is how he wants to exercise his discretion to say go and verify it, I don't think we respect that we can challenge that. That's my view on that. Then on who should fund the prosecution, that's from the man from Kogi. Well, my simple answer to that again is also that, of course, it's the state. It is the state. But what we see in practice is that the states do not indeed provide those required funds for the purpose of prosecution. I give you an example just from experience. There's a particular matter now I'm prosecuting on behalf of the state. And what is happening? You realize that to get a witness to come and testify in the matter, you have to personally fund the witness to come. Even state witness. Is that bad? So you realize that at the end of the day, it is more of an institutional problem, which has to be addressed one way or another if we really want to make progress in this.
Thank you very much. So, Chinelo. 1 minute.
Yes, sir. Quickly, the question is on Sunday Jackson, what was established by the prosecution? The simple thing the court said was that his confessional statement was admissible and it was the true representation of what happened. And so all the facts he stated there were now deemed he was convicted on the strength of his confessional statement and the established death of the victim. So there was an altercation, yes. Was he in his farm? No, he was in a bush. So it was not like he was protecting his properties. Do you expect someone in that circumstance to be of reasonable mind to count the number of stabs? I disagree. I think no. Whether it was 1 or 3, in the heat of passion, I do not agree that the person would think. And then the other question I asked in my paper, which I did not go further to address, is considering what we know now about farmer header, Nigerian header, civilian header, crisis ongoing. Can the court not take judicial notice that there is a serious issue of provocation ongoing across the country and that people will do whatever it will take to protect themselves, even if they disarm the person, knowing that if you leave this person to leave this place, they will come back and retaliate. That's my view. Thank you.
Judicial notice, a notorious fact. All right, thank you. Now, finally, from my own side, 2 questions and just 1 minute. Can oral evidence take the place of a certificate? What I have observed, even from my experience on the bench, is the fact that there is a confusion. People don't understand what Section 84 to A to D, which we always refer to as requirement for fulfilling conditions by oral evidence, and Section 84.4, which requires a certificate. Most of the time what you find is that all the conditions that are required to be made orally, they are embedded in the certificate. Whereas if you look at Section 84.4, particularly subsection 5, it says, oh, you are only required to make just one, or make comment or add one of all the 4 conditions in Section 84 to A to D. And so, my position is, the law under Section 84.4 says, there shall be. There shall be. So it is mandatory. Now, authentication of printer, phone, and a photograph, I think it will be wrong, I'm sure. Everybody even laughed here when that question was being asked. And that question too is similar to what happened in Dixon and Silva. Dixon and Silva, a case of video, DVD, yes, violence in Bayelsa State in an election, covered by Chinese television, made available the DVD, and the petitioner wanted to prove violence with that DVD and tendered it. It was admitted because all the conditions were fulfilled. I think it was between S.T. Horn and one other senior advocate of Nigeria. So he applied to play the video, and there was an objection, and the objection related to one, there was no certification of the screen that will show the video. There was no certification of the computer that will play the DVD, and there was no certification of. So unfortunately, again, just the same way somebody in the trial court here, the example given, fell into the error. The tribunal fell into the error and admitted that yes, there was need for certification of all the gadgets until the matter got to the Court of Appeal. Court of Appeal said no. It went to the Supreme Court. Supreme Court said no. You cannot add additional body on a party beyond what the law has required. Under Section 84, you are only required to authenticate 2 items. One, the computer that produced the document, and the document itself, period. So no other item is required to be certified. So with due respect, that court must have fallen into an error. Thank you very much. On this note, we have come to the end of this very interesting session. And on a personal note now, I want to appreciate the coordinator of the Rule of Law Development Foundation. I've been part of the foundation from the inception, and it is a pride for me, really, to be part of that, of this great mission. Somebody described it as movement at the inaugural session here. So I thank you very much. 7 sessions, and I have been part of all those 7 sessions. I've prepared 6 papers. I don't know why I've been asked to chair this, which I think I have been promoted now. Thank you very much. God bless you.
Thank you very much. The session now comes to a close. we'll take a 15-minute break and reconvene for session 2. The tea break is now served, so that please make your way to the reception for the tea break. 15 minutes, please, so that the day is fast spent. Yes, we are ready to proceed. All our speakers for session 2 are available.